We formulated 5 questions and we have answered them. We have set aside the order passed by the learned single judge. We have specifically observed that this judgment does not amount to restraining the parties from presenting fixed instruments for registration before the registering authority by making good the deficiencies which were noticed by the registering authority. We have the appellate authority set aside the order passed by will be equally open for the registering single judge to act in accordance with law. We have specifically observed that this judgment does not amount to restraining the parties from presenting fixed instruments for registration before the registering authority by making good the deficiencies which were noticed by the registering authority. We have the appellate authority set aside the order passed by will be equally open for the registering single judge to act in accordance with law. We have specifically observed that this judgment does not amount to restraining the parties from presenting fixed instruments for registration before the registering authority by making good the deficiencies which were noticed by the registering authority. We have the appellate authority set aside the order passed by will be equally open for the registering single judge to act in accordance with law. We have specifically observed that this judgment does not amount to restraining the parties from presenting fixed instruments for registration before the registering authority by making good the deficiencies which were noticed by the
Got to hear the matter and fix a date, but not listed, my lord. I have listed my witness.
Pardon, my lord.
Tender oblige, my lord.
Please,
First
admission.
first admission, first admission, my lord, writ appeal.
And why first matter shall be listed automatically?
Writ appeal, my lord.
What is the number?
Got to hear the matter and fix a date, but not listed, my lord.
1685.
I have listed my witness.
Pardon, my lord.
Tender oblige, my lord.
Please,
First
admission.
first admission, first admission, my lord, writ appeal.
And why first matter shall be listed automatically?
Writ appeal, my lord.
What is the number?
Got to hear the matter and fix a date, but not listed, my lord.
1685.
My
I
lord,
have listed my witness.
writ appeal number 1296. Pardon, my lord.
Tender oblige, my lord.
Writ appeal number 1296. First admission, 24. First admission, my lord, writ appeal.
Wait. First matter shall. And why
Due
first
to
matter
pendency
shall
of
be
writ
listed
appeal,
automatically?
the appeal am not appointment of
What is the number?
junior civil
Got to hear the
engineer.
matter and fix a date, but not listed, my lord.
1685.
My
I
lord,
have listed my
writ
witness.
appeal number 1296. Pardon, my lord.
Tender oblige, my lord.
Writ appeal number 1296. First admission, 24. First admission, my lord, writ appeal.
Wait. First matter shall. And why
Due
first
to
matter
pendency
shall
of
be
writ
listed
appeal,
automatically?
the appeal am not appointment of
What is the number?
junior
Got
civil
to hear the
engineer.
matter and fix a date.
Chief Justice and Billet's the then Chief Justice Muralidharan. Mruganka Shekhar
Maybe pardon.
And Niran Shekhar.
Sahu. Justice Mruganka Shekhar Sahu.
So this is how you address
No, Billet's.
the honorable judges.
Honorable Justice. Sorry.
All right.
Maybe pardon to make it. My lord, item 47 of today's list. I pray anytime you suit, so that matter be taken up and anytime after launch.
Hmm?
The matter may be taken up. 47,
47 we will take up.
my lord.
Please inform the other side.
My lord,
If it is not taken up in ordinary course, then we will take up the matter. Please inform the other side.
oblige.
I may pardon to make a mention, my lord. But item number 38, the lordship, my lord, that promotion matter to Odisha Taxation and Account Service, and your
We
lordship
had to defeat the judge.
also dictating the order. my
All
lord.
right. Okay. All
I
right.
prevent that. I'll taken up,
Pardon to make a mention, my lord.
Let us see.
my lord.
My lord, today's lit item 57 can be taken up today. Item 57. Can be taken.
What do you want?
Can be taken up today.
Can I seek your indulgence?
Reservation for Women Act. What is that act called? Odisha Reservation and Service for Women Act?
For women, my lord.
Huh?
For women,
For women.
that is Odisha Reservation for Women's Service. That is a resolution.
2040.
Whether that rule is applicable to the government employees or
Now only to government employees.
the employees of the university also.
Yes, they are adopting that.
The university has adopted.
Yes.
Is there any decision that the university has adopted? Because we are,
Yes,
we
I
are
understand, ma'am.
in the midst
There-
of
yes.
examining a point, and therefore just for the purpose of clarification, nothing else. We should be clear on law, therefore. So can someone give something to show that because the provision
I
of
will
the
give
act,
by. I will give by.
provision of the act indicates that it applies to the government only. So whether that applies to the university employees also,
I will give that by tomorrow.
please.
Can I seek lordship kind indulgence?
Item,
One review application preferred by the state against the order passed by the division bench. Now, in the meantime, your lordship has constituted a bench, but that bench has refused to hear this matter, your lordship. And as it's a division bench matter, and the order has been passed by Honorable Justice K. Panigrahi and the then Justice Sanju Panda. It has to be Justice Panigrahi has to be a member of that bench. So,
Rightly,
the lordship has constituted a bench, but after that they have. Okay.
no. All right, we will see. We will see.
I'm grateful. Your
This is not recusal.
But your lordship, the only difficulty is Justice Panigrahi has to be a member of that bench.
Yes, yes. So therefore, this order is not a recusal.
My lords.
No.
My Lord Justice, Panirai expressed that the other bench, by this member is Honorable Justice Das. They have heard this matter in extensive. That is why he.
So who had heard the matter?
The bench of Justice, Honorable Justice Das and Justice Panirai.
Oh,
They heard it.
So-
that matter.
oh, then that bench should have been
My
constituted.
lords.
That is that.
You're right.
I'm grateful.
Fresh writ appeal, my lord. Fresh writ appeal. Of 1929 of.
Please wait.
So this matter is relates to tax matter. Restoration is to be out of CMPL number 30 of 2020.
Restoration,
Yes, sir.
it has been dismissed by?
Sir,
When was that dismissed?
so it was dismissed by Honorable Chief Justice Mulidhar and Chief Justice Raman. So its matter can be taken as soon as possible. Thank you, Your Lordship.
may I pardon your lordship? Today's list, item 2, in last occasion, your lordship has asked for some query. I have sought for information through RTI. I need one more week.
Let the matter be called.
As your lordship
RTI
says. Obliged.
RTI on the basis of information which you received under RTI cannot be the basis for the courts to decide matters. RTI is a different proceeding altogether. And you please find out a judgment. There is a judgment on this point that the informations which you received under the RTI Act cannot be the basis for the courts to decide a matter. All right, because the information which they give may be incorrect. Don't know, may be insufficient, may be inadequate.
Item number 1. Before my senior starts, my lord, in this case, and also other cases, I have filed an application for intervention for the persons, those who have the GATE qualification, GATE certificate, scoring. But now the virus of that GATE scoring is under challenge before this honorable court, and the selection process is on. we are hopeful that we will get as per the rules. For the rules is under challenge, therefore I have filed an application for intervention. So my application may kindly.
So even otherwise, since the virus of a provision is under challenge, we have a duty to give you a hearing. So we will give you hearing, we will
Yes,
hear
sir.
you.
I have collected it only,
Even
I
if you
got all the judgment of, including one of the judgment of my lord at Bihar, Patna High Court. That is also there, my lord, but while sitting single, my lord have decided, and Madras High Court judgment, Madhya Pradesh High Court judgment, and I have collected another Punjab and Haryana High Court judgment. These are of the, but of the
Alright.
single judge,
Let us,
in my support. But only problem today I may face, my lord, if I will allow, the judgments I have get Xerox, but I have not kept in a serial or make it page mark, so that if my lord permit me, I will place.
no, let him begin.
Yes, sir.
Because
Counter page.
Counter, no, we have not got.
Counter affidavit,
No, no,
Sir, I don't know that.
they have not served.
cannot, is there any interim order?
And there is no interim order.
No, there cannot be any interim.
That
order.
no interim order, but the single judge has passed an order that you proceed to final result.
No.
So we are suffering, we are eligible
Single judge.
in terms of the statute.
No, not in my case, no, where
And about-
virus has been challenged.
How many writ petitions are there?
Well,
Four writ
One,
petitions.
two,
Four.
Four petitions.
No, three.
One writ appeal,
Three read petitions.
This appeal filed by me against the single judge.
one readable, three read petitions.
The writ petition relates to virus and
Three, four read
uh,
petitions.
and one writ is appeal is against the order.
Two read,
Just a minute. So, Mr., you are appearing in which? matter?
First matter,
First matter, writ petition,
yes,
challenging the virus.
yes.
And
Second matter is also,
so you are appearing in that also.
no, Mr. Pandit is appearing.
And third, writ petition,
my third read petition for the honorable single, that is single judge matter, that you also can find the last matter. That is the honorable,
No, no,
single judge,
that is a read.
that is the challenge, the advertisement.
challenging.
Advertisement.
Hold it.
Third is a read matter.
How, there is a read appeal is there.
In the fourth application.
Sorry.
For third is read appeal. Then the fourth is a read petition challenging the virus where Mr. Rautra is, Buddhadev Rautra is appearing. Then the fifth, I don't know.
Fifth night.
out of last.
ସେଇଟା କଣ? Virus? Oh, that is
So
also.
So the best course would be that you start your submission on the point of virus.
Yes. But
Alright.
I have a very small and subtle point.
That-
If your lordship appreciate it, it is all right.
So therefore, yes, so therefore we should start with the virus. And then if required, they may be asked to file counter affidavit. Otherwise, generally in virus matters.
You have just now, sir.
I have filed counter affidavit and I have solved also.
But where, what is the question? What is the
I don't know.
purpose of counter?
Except that whether this, there is a discrimination and if the discrimination result in a objective rational nexus. That is what they will say, what is the rationality behind enacting this amendment. Except that counter, I don't think would be necessary. The rest would be the questions of law.
Exactly. So what do you suggest?
One day, 2 days, let me go through it.
All right.
Let me know
All
what
right.
is their objective.
Yes, sir.
Next.
And see-
Council.
And after a division bench struck down similar amendment, there again came out amendment with a cosmetic change.
Which division bench?
Of this under court, my lord, my honorable just. There are two grounds. my
Consultation
lord.
was not met with the
Nice.
ESG. That was the consideration for which.
Yes,
Yes.
Yes. like that.
Letter went to
That
Supreme
rule,
Court and Supreme Court
does not
declared it
survive.
in proctus because by the time the
New rule
statute
came
had
and
been new rule came.
rule repealed.
So that,
Therefore, there
And the
is no question for consideration by the apex.
that is,
All right, we will hear all of you.
I have also filed an intervention matter in.
Just a minute, we will
Can it-
hear all of you.
Well.
But before you start your submissions, please make your plan outside the court. Who will begin and who will reply?
Then we have to-
On whose behalf?
No, we are-
On whose behalf? Like who will begin and who will reply on whose behalf?
No,
right.
I think we have, I have also told them, Mr. Pandit and Mr. Rautrai, that we divide the points.
Right.
So I will urge one point, and instead of encroaching upon their submission, they will, instead of repeating, they will go argue two
Absolutely
different
right.
points, so that it will be easy instead, and save time.
All right. So Wednesday?
My lord,
Holiday.
Wednesday
Wednesday
is
is a
holiday.
holiday.
When do you want?
I was praying, my lord, any day, not on 18th and 23, my lord.
18th and 23.
22nd?
No, 22nd, I am not here. That is why I am.
24.
So 24th?
Yes.
24, it is all right.
Any objection?
No,
My lord,
May I claim that at 2 p.m. the lordship can fix it at 2
No, no, at 10:30.
Yes,
First-
obliged,
All right.
obliged.
I beg your pardon, Lord. I have filed an IA for intervention. That has not come, my lord. That
Will
may
come
be
then.
taken next week.
All right. That will be listed.
I think that.
See,
I
in
think
virus
if it-
matters, Mr. Counsel,
If it is necessary, they can add.
Mr. Counsel, in virus matters, intervention is immaterial.
Yes, sir.
So if someone wants to make submissions,
Yes, sir.
we are
But
there to hear.
Just want to bring some facts on nothing else.
As
Your lordship is
requested
fixing it to 24th, my lord.
by Mr. Mohanty and senior counsel, appearing on behalf of the petitioner in WPC number 10185 of 2024. List these matters on 24, retaining its position.
Item number 2,
The IC is not functioning. Yes.
In this, your lordship, I had a query that about the upgradation, your lordship. As per the clause 8 at page 54,
So what do you want? Why were you making a mention?
because I have sought some information as regard to this only, which I will get by this week. That's why I want an adjournment up till Monday, your lordship, next Monday.
As requested on behalf of the petitioner, appellant, this matter on 1 week. Mm-hmm. 23rd.
Oblige, your lordship.
item 3,
Who read the applications? Consent to get sand soirat. ଦେଇଛି ନାହିଁ ଆଜି ମୁଁ ଦେଇଛି last time your lordship directed a copy I have served it.
I'm just finding some.
I'll file another I'll in course of the day let's say may fix it
No, your
if
lordship,
not it's with him.
I can go through the copy here. Yes. Oh, yeah, I see. It is already operating. It is full.
Who read application is relating a sand soirat.
But your appeal was dismissed on in 2021
Madam.
and you filed this writ petition in 2023.
My lord, I approached this honorable court, a representation was made, then I converted it to refund. Refund also refused. Therefore, the other writ application.
Where is that order?
My lord, my honorable High Court's order.
Hmm?
Annexure 7, the first writ application, 22080.
So you
I can
file a
simply say
representation against the
representation
order
is
of the
given.
appellate authority.
So two, well,
You file a representation.
no, appellate authority regular appeal. Representation for refund. That was rejected and another writ application, the subsequent one was filed.
Firstly, this appeal is of 2021. We are in 24. And secondly, your lordship will find Rule 46(2) also provides that this appellate court's order is also revisable before the RDC. That your lordship can see Rule 46.
The demand notice you had filed representations,
Mal-
not appeal.
Not a,
And so this.
appeal is against the order of the.
Disposed of directing disposal of your representation.
Appeal arises out of the order
Mr.
rejecting.
Mishra, I'm asking you after seeing this last order.
Mal-
So you had challenged the demand notice.
My lord.
Against the demand notice, you preferred representation instead of appeal.
No.
That is the order.
No. Appeal is filed against an order rejecting my application and granting it to a different party. That was filed.
Annexure 7.
My lord. But subsequently, by after the representation, a order was passed rejecting my refund.
Just one moment, little confusing because the order says
May I prepare a note?
you have filed the
Hello,
appeal for quashing the demand notice bearing number 32 and 33.
My lord.
Wide annexure 4 series. Thereafter it is said that you have filed representations.
That representation was rejected. And the other writ application,
Where is the question of
this.
Mr. Counsel, where is the question of representation against statutory
Statutory.
order of appeal?
My lord, twofold prayer. One is rejecting my application for a tender and granting it to the author. That is appellable. I have preferred appeal. Then I challenge the order before the Honorable High Court. Honorable High Court says a representation. I filed that representation. That was rejected. So also I filed this another writ application. One challenging the appellate order, one challenging the demand order refund.
High Court did not say file representation. High Court said representations are pending. You had already filed representations.
Well,
if the order is
now that was disposed of. Your Lordship may take off the second writ petition. The rejection order is there.
That is against the demand. But here the prayer is to quash the order of the appellate authority. That is at Annexure 5. That is the root of the matter.
Annexure 5 is dated?
Annexure 5 is dated 26/10/2021. Your lordship may see the prayer in the writ petition. Quash the impugned order number so-and-so by Annexure 3 and appeal order by Annexure 5.
Just a minute. So when you file the previous writ petition, did you challenge the order of the appellate authority?
Yes.
No.
That is right.
That I challenged, my lord.
You did not.
My representation has been considered and rejected.
Question of
That
representation.
representation relates to demand.
This appellate order is now challenged before my lord.
So we will not consider.
My lord, now the statutory remedies are exhausted.
No, not adjusted. RDC is there, appellate authority. Rule 46, your lordship may see collector's order can be challenged before the RDC. Rule 46 of OMMC rules. If the order is passed by collector, then it can be challenged before the RDC.
Mr. Counsel, your client is very smart.
No, my lord.
The first order was passed.
My,
Demand notice was issued on 12/3/2021.
my lord.
You preferred an appeal.
My lord.
The appeal was dismissed on 26/10/2021.
My lord.
You filed a writ petition in 2023.
My lord.
You did not disclose that the appellate order has been passed. You took a plea that you have filed a representation. The court directed that that representation be disposed of. And now the order which was passed in 2021, you are challenging in the present writ petition.
My lord,
So when you did not, did you challenge this order dated 26/10/2021 in the writ petition which was filed in 2023?
that copy is not with me.
That copy is with us.
That
Make
earlier
sure.
writ petition, what was assailed,
What was assailed? We don't know. What was assailed has been noted in the order.
my lord, I have.
This one, sir. Put up this case tomorrow along with the records of WPC number
4189 of 2023.
4189 of 2020. Tomorrow.
Item 4.
Please permit me to speak in Urea. Please permit me to speak in Urea.
Yes, your
Which is
lordship
my-
directed to get from some in the matter last date. We have communicated and they are preparing the Paraway's comments. Lordship will grant me 2 weeks.
Preparing?
The Paraway's comments and they will file it within 2 weeks maximum.
Sir, please permit me to speak in Urea. ଜୀବନ ସହିତ ଖେଳିବେ ଆହୁରି କେତେ ଦିନ ଗୁଚିବେ ଲୋକମାନେ ଯୋଉ ହଇରାଣ ହଉଛନ୍ତି ଆପଣଙ୍କର
Oh,
Mr. Jenna, can his lordship understand Odia?
ନାଇଁ,
No, I will understand, but his lordship also has to understand. Speak in
My
Hindi
case is
otherwise.
that, your lordship has last order directed me to take instruction. So I have to file a counter affidavit. So counter affidavit, only 2-3 weeks time.
file counter affidavit. Counter
Last-
affidavit another.
3 weeks time, last chance.
By way of last indulgence, 3 weeks time. is all.
What a chance.
ବହୁତ ଲୋକ ମରିଯିବେ କେତେ ଲୋକ ଆଉ ବର୍ତ୍ତମାନ ଦେଖନ୍ତୁ କାଲି ତ୍ରିଶା ହସ୍ପିଟାଲ ଆପଣଙ୍କ ଘର ପାଖରେ ହେଇଛି ଯୋଉ ଭଳିଆ ଲୋକ ଆସି ହଇରାଣ ହଉଛନ୍ତି ତାଙ୍କୁ ଟାଣି
ହଁ
ନଉଛନ୍ତି
ଯେ, କିନ୍ତୁ ତାଙ୍କ ରିପ୍ଲାଇ ଟା ନଥିଲେ ଆମେ ତ
ତେଣୁ
ଅର୍ଡର
ଏତ
ଦେଇପାରିବା
ଗଡେଇ ଗଡେଇ
ଗୋଟେ
ଚାଲିଛି
ଚାନ୍ସ
ଲୋକଙ୍କ
ଦିଆହଉଛି
ଜୀବନ ସହିତ ଖେଳୁଛନ୍ତି ତାମାନେ
ଗୋଟେ ଚାନ୍ସ ଦିଆହଉଛି ଆପଣଙ୍କ ଏକ୍ସାକ୍ଟଲି ପ୍ରୋବ୍ଲେମ କଣ?
ମୋର ପ୍ରୋବ୍ଲେମ ନୁହଁ ଫର ଦ ଗ୍ରେଟର ଇନଷ୍ଟେଡ ଦ କମନ ପିପୁଲ ଅନ୍
ହଁ
ଟାଉନ
ହ୍ୱାଟ?
ତାଙ୍କ ମାନଙ୍କୁ ସେବା ଦିଆ ହଉନାହାନ୍ତି ତାଙ୍କୁ କିଏ ମସୁଲ ଆସିଥିବେ ମେଡିକାଲ ଯାଇ ଯିବେ ସେଠି କହିବେ ଖିଆ ହବନି ଚାଲ ଅଶ୍ବିନୀ
ଠିକ ଅଛି
ଚାଲ ଆପୋଲୋ ଚାଲ ସଦଗୁରୁ ସେଠିକି ଯିବେ ଆଜ୍ଞା ସେଠି ଗୋଟିଏ ଗୋଟେ ତେଣୁ ସେଠି ଯୋଉ ବୋର୍ଡ ଗୁଡା ମାରିକି ନଉଛନ୍ତି ପ୍ରତ୍ୟେକ ନର୍ସିଂ ହୋମ ଆଗରେ ସେ ଲୋକ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଡକ୍ଟର ବୋର୍ଡ କାହିଁ ରହିବ ସେମାନଙ୍କୁ ଗୋଟେ
ଠିକ ଅଛି ଗୋଟେ ଦିଅନ୍ତୁ ତାପରେ
ସେମାନେ ଦିଅନ୍ତୁ କିନ୍ତୁ ଲୋକଙ୍କ ସହିତ ଜୀବନ ସହିତ ଖେଳିବି ନା ଆଗ ଥର କହିଥିଲେ ପ୍ରଥମ ହେଇଥିଲା ବୋଲି ମାନ୍ୟବର ଚିଫ ଜଷ୍ଟିସ ଯେତେବେଳେ ଅର୍ଡର କରିଥିଲେ ସେ ଥର ଟିକେ ଖାଲି ଶୁଣିଦେଲା ପରେ ଓଡିଶାର ଗୋଟେ ଚହଳ ହେଇଥିଲା ଯାହା ଗୋଟେ ଭଲ ଜିନିଷ କରାହେଇଛି ଓଡିଶା ମୋ ଅନୁରୋଧ ଲୋକଙ୍କ ଜୀବନ ସହିତ ନ ଖେଳା ଏଇଟା ଲାଷ୍ଟ ଥ୍ୟାଙ୍କ ୟୁ
Item 5.
Item 5, my lord, last occasion, the delay was condoned. Somehow my learned senior has not received a copy of the appeal memo. I'll serve today, my lord, in course of the
Get a
day.
copy of the memo of bill which served upon and counsel representing the respondent in course of the day.
In course of.
Will is this matter on 1 week?
And next week, then it.
क्यों इसी में काम कर रहा है? Can you inquire?
ଏସି କାହିଁ କାମ କରୁନି ପର୍ଯ୍ୟବେକ୍ଷଣ ମାନେ କମ୍ପ୍ଲେନ ଦେଇଛନ୍ତି ଯେ what is the problem?
Yes.
Possible to see.
Item 6.
May I please your lordship?
Yes.
Common judgment in 2 writ application filed by the appellant and respondent number 5 is under challenge.
Yes.
Even if the appellant has filed WPC number 13,448 of 2023, 22, the prayer, averment, and also findings with regard to the writ of the appellant
What is AWH?
Pardon?
What is AWH?
Anganwadi helper. The case of the appellant is that 4 candidates, including the appellant and respondent number.
You had filed the writ petition.
I filed writ application number 13,448 of 2022. And the respondent number 5 filed the writ application bearing number 35492 of 2023. Common judgment was passed, but in the writ application, neither the prayer of the present appellant nor the averments nor findings has been given and directed to discharge the present appellant within a period of 7 days. Nothing has been mentioned. Everything has been mentioned with regard to the writ application filed by the respondent number 5.
What happened in WPC 13448 of 2022? That you indicated but not given the order.
In the order, it has not been mentioned. With page 67,
Have you mentioned?
pardon ma'am.
Have you mentioned?
No, my lord, in the judgment, nothing has been mentioned with regard to the writ petition of the present appellant. In the last paragraph, with respect to the aforesaid submission, this court, the submission of the present petitioner with regard to writ petition number 13,448 has not been mentioned in anywhere of the judgment. And lastly, is that the CDPO is directed to discharge the respondent opposite party number 5, the present appellant, from the post of Anganwadi helper within a period of 7 days. In the last paragraph. Nothing has been whispered in the judgment regarding my writ application.
So there was an advertisement.
Pardon, my lord?
There was an earlier advertisement.
Yes, ma'am.
Against which you had applied.
Yes, ma'am.
You were not selected. The other respondent number 5 was selected, or opposite party number 5, whosoever.
No, my lord, I was selected.
You were selected.
Yes.
Your selection has been found to be illegal.
I was, engagement order was issued in the year 2020 and I joined in the service. Thereafter, the respondent number 5 preferred appeal. Before the filed writ application before the Honorable Court, directing to reconsider his repentation. And this Honorable Court directed again to file a repentation before the sub-collector and he will consider in accordance with law. Thereafter, she filed Anganwadi Miss case before the sub-collector. Even if I was appointed engaged in the year 2020, I was not made as party in the Anganwadi appeal, Anganwadi Miss case. So, Lordship, kindly have a glance to the Anganwadi Miss case. At Annexure 9, page 47, as well as page 44, Annexure 7. The present appellant was not made as party. It was filed in the year 2001 and I was appointed in the year 2020. I was not made as party. Even if I was continuing in the post of Anganwadi.
You were heard whether in the
No, my lord, no opportunity was given
In
the
writ proceeding before the learned single judge.
single judge, I was heard, but in the after 4 months or 5 months after judgment was pronounced. But regarding my writ application, nothing has been mentioned.
You should notice. Yes. 1 week, refusal is in 1 week, 8 weeks.
Now the appellant will be allowed to continue.
In the meanwhile, the parties shall maintain itself as on today.
Item 7.
May I plead your lordship? Your lordship, in the earlier occasion, your lordship had put a query on me that whether an order which is passed on the basis of a concession given by the council appearing for the party, whether that order can be challenged in a review. Lordship, my humble
In a
submission.
review.
Your lordship,
Yes.
my humble submission subject to your lordship's acceptance is, if a concession has been made and the court has proceeded in a misconceived manner on the basis of that concession, only on that ground a review can be preferred. I would support my submission with a decision of the Honorable Supreme Court reported in 1954 2 SCC, page 42.
Yes.
May I
Give
place
us-
that judgment? Lordship, in this
So
case,
where is the concession?
the concession is at page paragraph 29, your lordship. Paragraph 29 at
Paragraph 29 of. This is WA 18816.
your lordship. Yes, your
Is
lordship.
this WA 18816?
Yes, your
Where
lordship.
is the concession?
Sorry, your lordship, I'm referring to the judgment here. The concession is at page 107 of Annexure 9. Annexure 9 at page 107.
Yes.
May I place your lordship?
Yes.
Even though learned counsel appearing for the university vehemently contended that the guideline framed by the university and under Annexure 3 is to be followed for recruitment of faculty under CAS in terms of notice issued on 30/6/2023 under Annexure 2, but in course of hearing, learned counsel appearing for the university contended that university has no objection to follow the guideline so issued by AICT in its notification dated 1/3/2019 and notification dated 25/2020. But it is contended that in the guideline framed by the university under Annexure 3, so far as it relates to securing a score of 60 or more mark to qualify for the position, be allowed to be followed by the university instead of the score prescribed by the AICT at 50 mark. Your lordship, the next two paragraphs are also relevant. May I be allowed to place?
Just wait. So what was the issue involved briefly?
The issue involved was that a notice was issued by the university inviting applications for promotion to the post of professor. So as per the notice, any candidate who satisfies minimum eligibility criteria prescribed in AICT guideline 2019 can apply for the post of professor. Your lordship, in the AICT 2019 guideline, only the minimum eligibility criteria was prescribed. There is no procedure prescribed for regulating the selection process. So in that case, the university, being governed by its own statute, framed its own guidelines for regulating the selection procedure. Those guidelines were approved by the government as well. Now, after that, the applications were invited and these petitioners had also applied as per the guidelines framed by the university. Then they filed a writ petition challenging the guidelines framed by the university.
Who?
The present respondents, the petitioners, who were the applicants under notice issued by the university. So they challenged the guidelines framed by the university on the reasoning that AICT guidelines should be followed, and the procedure which has been prescribed by the university should be quashed and should not be resorted to while regulating the selection procedure. The university filed its counter, then stating that the university being governed by its own statute, and since no selection procedure has been prescribed in AICT guideline 2019, the university can form its own selection procedure as per the guidelines prescribed in the statute of the university. Then, Your Lordship, the petitioners filed an additional affidavit before the learned single judge, stating that AICT guidelines 2012 can now be resorted to because a selection procedure for regulating promotion to the post of professor has been prescribed in AICT guidelines 2012. Then university filed a reply to that. In the reply, the university has stated that as per clarification made by the AICT in 2020, any applicant who has made an application under AICT guidelines 2019 cannot be governed by the selection procedure under AICT guidelines 2012. Now, after filing this reply,
12 or 20?
Yes, Your Lordship.
12 or 20?
Clarification was issued in 2020. As per the clarification of the AICT, any applicant under AICT guidelines 2019 will not be governed by the selection procedure under AICT guidelines 2012. So after filing of the reply, there was no instructions given to the council. The council, during the course of hearing, had made an admission that the university has no problem in following the AICT guidelines 2019 and the clarification dated 2020. These were the admissions given by the council. Now, what was held in the order that the university has no objection in following the guidelines AICT 2019 and also AICT 2012. No admission was made regarding AICT guidelines 2012. That portion of the order was passed without any discussion and without any analysis, Your Lordship. And the university has taken a clear stand till the last date that we will follow the procedure which has been framed by the university, and it has also been approved by the government. Now, Your Lordship, a question arises here whether an university which is governed by its own statute can frame its own guidelines to regulate the selection procedure. In a decision of Honorable Supreme Court in APJ Abdul Kalam University, the Supreme Court has held if the university is governed by its own statute and it frames its own guidelines, which is an enhanced form in comparison to the AICT guidelines, then the university can regulate the selection procedure or can perform any function according to its own statute. Also, Your Lordship, in a judgment of Honorable Supreme Court 2001 SCC, it has been clearly recorded that AICT is not a controlling authority, Your Lordship. AICT guidelines are merely regulatory. They cannot supervise.
That prescribes the minimum standard according to it.
Yes, Your Lordship. The university cannot.
So what is the difference between the guidelines issued by the AICT 2019 and the university guidelines?
Your Lordship, in that regard, may I place those guidelines, Your Lordship? The relevant portion.
Just the basic, what are the silent features of?
Yes, Your Lordship. Your Lordship, as per the AICT guidelines 2019, only the minimum eligibility criteria has been prescribed. Like Your Lordship, for the
university guidelines prescribe higher
enhanced form, Your Lordship, and there is no regulations in the AICT 2019 guidelines to regulate the selection procedure. Only the what the AICT 2000 guidelines has prescribed is that
all right, we are issuing notice.
Obliged.
You are Mr. Sahu?
Yes, your lordship.
S Sahu,
S Sahu, your lordship.
Yes. If you notice, 1 week, 8 weeks.
A pleasure.
Item 8,
Made Pijolot. That matter where after the legal heirs of the original lessee from the Raulkela Development Authority having succeeded or inherited the property of their late father, the question arose whether the Raulkela Development Authority, without the consent of other legal heirs of the original lessee, can allow the mother in whose name the other legal heirs had consented to be leased. Whether the mother in whose name the press lease was executed by Raulkela Development Authority.
So you must have wanted for some amicable resolution.
That your lordship suggested, but it could not with the present petitioner wanted to have some amicable settlement, but he was not allowed to meet his mother. That was the difficulty, nor the other family members gathered, that was the difficulty. So now your lordship wanted to dispose upon merit. Question is section 8 of the Hindu Succession Act, all the legal heirs having simultaneously succeeded to the property of their father, can the mother alone alienate? The Honorable Single Judge has said in paragraph 15, the concluding paragraph, if your lordship permits, I will read out.
No, who is the lesser?
Lesser is the late father of the present petitioner. Oh, lesser is Raulkela Development Authority. I'm sorry.
Raulkela Development Authority
Yes.
is the lesser.
Yes.
So the lease was in the name of?
The father of the present petitioner, Vasant Kumar Das, late Vasant Kumar Das.
Late?
Vasant Kumar Das.
So he died when?
15/5/2006. 15/5/2006. Yes, I have given a.
Then what happened?
Thereafter, the other legal heirs of the original lessee consented that it be renewed in favor of the mother.
All right. So a lease agreement was entered into
Yes,
between RDA and
the
wife.
widow of the original lessee.
4/8/2010. No,
Yes.
no, sorry.
Yes.
16/7.
Yeah, so what right do you have?
Pardon?
The lease agreement was
Yes.
initially entered into between RDA and Basant Kumar Das.
Yes,
It's a different matter that you consented to that,
yes,
but the fact remains that there was another lease between RDA and your mother.
yes, yes,
So how do you explain that? If you had any right
yes.
to succeed, all right, then you could have raised your objection at that point of time.
Yes.
No,
The
it was,
lease agreement ought not to have been agreement entered into between RDA and the widow.
no, it was only a consent given that let that be in the name of our mother. But at the same time, your lordship will kindly appreciate section 8 of the Hindu Succession Act has come into operation.
8 of the Succession Act had come into operation on the
Yes.
date of death,
Yes.
15/5/2006.
Yes,
You allowed a lease to be entered into between RDA and the widow.
widow.
Then how can you say that your name should be included?
Had there been, my respectful submission would be, had there been any deed of relinquishment which would have conveyed the title in favor of the mother, then I had no say over the matter.
question of title, the lease deed.
Lease deed, yes, that the legal heirs having simultaneously succeeded, that has been also decided in the judgments of this honorable court. I have cited something.
I beg your pardon, my one factual error that this is not actually a lease because Raulkela Development Authority is the lessee from government. This is a sublease. Just a factual correction. This is a sublease to the LRT because Raulkela Development Authority itself is a lessee from the government.
So was there any term in the subsequent lease agreement that it was because of your consent or something? Is it there?
That was asked for by the
No.
town.
Any recital in that
No.
deed
That
regarding
I have
this?
not checked out.
Then you don't have any case.
In fact,
So your,
What did you do thereafter? Have you challenged the,
let me verify the lease deed as your lordship.
why
put the
verify?
question.
Unnecessary, we gave you a chance. Now, as we had rightly observed, that we will decide it on merits.
The concluding paragraph of the impugned judgment, your lordship will kindly find at page,
Just a
paragraph
minute.
15. Application for third party transfer, may I read out?
Application for?
Third party transfer by the widow,
Ah.
the subsequent lessee. Application for third party transfer of the case house was rejected by the RDA only on the ground that that after death of the original allottee, all the legal heirs have equal right, title and interest over the suit property. Apart from that, one of the legal heirs, namely Paresh Kumar Das, the opposite part number 5, the present appellant, was filing repeated objections stating that his mother has no right, title and interest to transfer the case house. Such an observation has no legal basis at all in view of the fact that lease cum sale deed under Annexure 2 in respect of the case house has been executed in favor of the petitioner only. Thus, the opposite party number 5 cannot have any objection with regard to right, title and interest of the petitioner in respect of the case house. No relinquishment deed / NOC from the legal heirs of late Basant Kumar Das is necessary for according permission to the petitioner for third party transfer of the case house, as none of the legal heirs except petitioner has any right, title and interest over the case house after the lease cum sale deed under Annexure 2 was executed. Here my respectful submission would be that in the absence of a deed of relinquishment, once they have.
Absolutely. The view is absolutely correct. The view taken by the learned single judge is absolutely correct.
My submission is to the contrary on the basis of decided cases of simultaneous succession.
Maybe.
And in the absence of a deed of relinquishment, which otherwise prevents one from claiming any title.
Yeah.
This is only a consent, given that the lease be renewed in the name of the mother, the widow. Nothing
Wait
beyond
for-
that.
Wait for your obedient children, wait for her death.
Pardon, my lord?
See, you are the children of that mother.
Yes.
Right. You can wait for her death.
Pardon, my lord?
You can wait for her death.
Before that, if she sells away, then
That she can do.
my respectful submission is that the law doesn't permit her to exercise absolute
All
right in the absence of deed of relinquishment by the other legal heirs
How can
of the
she sell?
original lessee.
How can she sell? She is the lessee. How can she transfer?
She made an application to alienate.
Center.
The
No.
objections were called for by the RDA from the other legal heirs of the original lessee. This present appellant objected, saying that mother alone cannot, because we have all simultaneously succeeded to the lease
Objections-
right.
Objections must have been called for because you objected, otherwise there is
No. Objection was
Well-
initially called for by the Rourkela Development Authority, since they had only consented without a deed of relinquishment of any right over the leased land of their father. The consent was given that yes, the lease may be renewed in the name of their mother.
One point is missing, my lord, because they require a prior permission of development authority for any transfer. When they sought for prior permission, I sought for you obtain no objection from the other legal heirs. That's a clause.
Absolutely correct view has been taken by the learned single judge. See paragraph 7.
Yes, since the issue involved, may I read out? Since the issue involved in this writ petition relates to absolute ownership claimed by the petitioner, the civil court is competent to adjudicate the same. Hence, the writ petition is as laid down is not maintainable and is liable to be dismissed.
There was
And
a
on-
submission.
Ultimately, in paragraph 15, the conclusion was, despite the fact that there is no deed of relinquishment,
C has the right to alienate the
Alright.
subsequent lessee.
That was submission. Right.
I rely on the citations. Hmm. 1989, volume 3 SCC, page 77. Volume 3 SCC, page 77. Because here it is a question of tenants in common, joint tenants, not tenants in common. In case of joint tenants, everybody has simultaneously succeeded to the property of their father, to the leased property of their father. In 89, volume 3 SCC, which was later on followed also by the Honorable Supreme Court, the Placitum part, it was held on the death of the original tenant, subject to any provision to the contrary, either negativing or limiting the successions, the tenancy rights devolve on the heirs of the deceased tenant. The incidents of the tenancy are the same as those enjoyed by the original tenant. It is a single tenancy that devolves on the heirs. There is no division of the premises or of the rent payable thereof. Therefore, the heirs succeed to the tenancy as joint tenants. In the present case, the respondent acted on behalf of the tenants. He paid rent on behalf of all, and he accepted notice also on behalf of all. In the circumstances, the notice served on the respondent was sufficient.
You are relying on this
Is it for against you or?
Pardon me?
1989-3.
89-3 volume.
So that
SCC.
arose out of a suit. This decision,
Yes, but the principle has been enunciated.
maybe principle has been initiated, but that principle will not follow in bid rejection.
May I pray one thing? If your lordship gives me the liberty to approach the civil court
You can
for
do that.
appropriate remedy.
You can do that. Yes.
In fact, I have solicited both the parties to go to civil court,
No,
but they
Malika,
didn't
it
agree.
is not like that he is mediating. I'll just clarify one thing. Only one addition. My initial allotment in favor of the predecessor was only merely an allotment letter, not a lease deed. So what I humbly beg to submit, once it is an allotment letter, question of succession and all those things doesn't arise at all. And mere no objection was obtained while granting the lease deed in favor of the mother respondent number 1. So therefore, it becomes worse for them for the reason that initially had there been a lease deed, question of claiming a succession or for that matter, questioning a claim of relinquishment in favor of the mother would have arisen. With her lordship's kind.
Why the lease deed was executed in your favor?
Married.
Why?
My lease deed was executed in my favor because the mother applied before the Routledge Development Authority on death of her husband for lease of the land in her favor, because by then there was, I'm furnishing a debt chart with your lordship.
No, forget that. Let us understand.
Yes.
Debt chart is immaterial.
Right.
A lease deed was executed in your favor.
Yes.
By RDA.
Right.
Which is stayed within the meaning of Article 12.
Right.
All right.
Right.
Why was the lease deed executed in your favor?
Lease deed was executed in my favor on the basis of an application made by me.
Why? Anyone could file an application for execution of lease deed?
Right. I am conscious, my your lordship, so far as the allotment letter is concerned, what I humbly beg to submit, there was a right to possession. No doubt he had paid the amount for the purpose of getting the allotment done. But so far as the lease deed is concerned, unfortunately or fortunately, by the time of his death, there was no lease deed in existence. Whereas, I will show from record to your lordship.
We are again repeating the same question. Why was the lease deed executed in your favor?
Because obviously, because I happens to be one of the successor of the person's house.
Exactly.
There is no denying
They
of
are
that
also
fact.
successors.
There is no denying of that fact.
So they are also successors.
That I humbly beg to submit, your lordship will decide whether the allotment letter will confer any right or not, number 1. Number 2, I want to show to your lordship, they had 5-6 of pieces of like these houses and plots, 2 or 3 by the Routledge
We will
Development
not go
Authority.
into that.
May I just point?
We are not required to go into.
May I just point out one thing, Your Lordship, how he is appropriating and reprobating in the same breath. What has happened?
He may be doing whatever he wants to.
That
do.
is not
We have to
permissible
finally
also,
decide.
May I just point out one thing? What has happened in respect of other allotment made by the RTI authority, no objection given by other, because these are all family arrangements done. They had 10 pieces of land. So there are 3 sons, 1 daughter, then the mother.
Therefore, we are making all these observations that these facts cannot be gone into in a writ proceeding.
So he has to question.
He is saying that
he has to question, because I'll also satisfy on the
Mr. He is just seeking the court's liberty to file a suit. That's all. The difficulty which he will face, that if we don't set aside this, if we don't make any observation as regards the finding recorded by this court, he will lose this will prejudice his case.
Will your lordship only see the rejection order? So far as the Routledge Development Authority is concerned, the rejection order, my lord, my humble submission would be what they had sought for, and the rejection is misconceived, because your lordship may only kindly see the rejection order. Rejection order by the Routledge Development Authority. That is at page 27 of the writ petition. What they in fact want, the last paragraph. They say, after considering the objection of the present appellant, therefore, for consideration of you above referred to application for transfer of allotment, you have to submit the registered relinquishment deed / NOC in the shape of affidavit from the executive magistrate of other 4 legal years of the original allottee. So therefore, they wanted either the registered relinquishment deed or NOC. NOC has been filed. That was annexed to the writ petition. So therefore, if they want either of the two, then in that event.
NOC for what?
NOC for this transfer. NOC for transfer.
No, it is
Mr.
for mutation.
Mr. Mishra,
It is for mutation.
NOC was for registration and name of the mother or for transfer?
NOC was
granted by the appellant.
For registration.
Yes.
So therefore, NOC was already in existence.
NOC was for mutation. NOC was for mutation. She has paid mutation fees, and it has been mutated after considering the
Therefore, your
objection.
lordship sees the mischief after it.
No, mischief. Don't use these expressions.
No question of mischief.
So I was also citing 2 authorities on the point that an allotment letter cannot confer any right. I'm just citing it for your lordship's kind consideration.
Then if we accept your submission, then we may have to set aside the lease agreement altogether.
But that your lordship will decide. I am to assist your lordship, Mara. I am to assist your lordship. Such a question arose that was whether the allotment order can confer any right for the purpose of mortgaging the property in one instance. Then in another instance, the question was whether there will be any claim of right in both the cases.
Matter of curiosity, what is the problem? Why are you not granting consent? You want part of that proceed?
Only on our no objection or consent, it was in favor of our mother.
Yes.
Otherwise, the RDA
Yes. Now the transfer is in whose favor?
transfer the
My third party.
third party.
Third party.
Third party is who?
He is no way connected to the family.
Outside.
Outsider. Do you
Yes.
want to buy it? Because sometimes there is first.
Yes.
They might be interested in buying it.
And he has taken 3 numbers of properties. During that settlement where no objections were given, interchangeable,
In fact,
he has taken 3 properties, Pilot.
Mr. Counsel, we are bound by law.
Right. I'm conscious. 2 from Routledge Authority itself.
Our decisions will not be influenced by any other.
Conscious of that,
They
Pilot.
have got this, they have got that. Might have got that.
May I be permitted to submit? In fact, the appellant wants, if the lease continues in favor of his mother, he has no objection, nor any other legal heir has objection. Only when the question arose and the RDA sought for no objection, this question arose.
Third party transfer.
For third party transfer.
And one more
Those
point,
are the-
if your lordship permit me, my predicament is the entire cost has been paid by the predecessor. But lease deed, before the lease deed could be executed, he expired. Therefore, I wanted no objection for mutating the land in favor of 1 or 2 allottees so that I can communicate with
You
them.
are for the RDA.
Yes.
For the-
Right. Yes, number tapar.
So my predicament is cost is paid by original allottee Vasanto, No lease deed was there. No objection obtained for mutation. After mutation, lease deed has been done.
Third, put up. Tuesday, sorry. Tuesday. Wednesday. Wednesday,
Wednesday means next Wednesday. 24th.
24th.
Obliged. I have submitted the citations that I rely on.
Citations.
I am also filing my date.
The order which we intend to pass is that we shall record our disagreement with the finding recorded by the learned single judge to the effect that they were not required to this thing, the relinquish deed, requirement deed. So we shall open that, keep that issue open to be decided by a civil court of competence. This is what we intend, if they challenge. Otherwise, they will not do anything. We will not decide his right or your right.
Obliged.
I am only filing that note. It's only a date check, nothing beyond that.
See, now the honest. Time, it takes time. Yes. Otherwise they switch it on, I think, 3 AM or something.
Yes, next.
Item 9.
Item 10 we take up first. So the item 9 and 10 both are same, but in the 10 there is some more documents.
And you are appearing in both?
Yes, with the applicant. In this case, I am challenging the impugned order dated 1/5/2024 by the Annexure 18, page 66. I have challenged after getting the information in RTI Act, though I have selected the post of district science supervisor in a by the district selection committee, but the DO without any procedure, he has recommended the name of respondent 4, and the DO has given the information that there was no.
No, but where is the order? Come to paragraph 6 of the order.
Yes.
The issue has already been decided.
Yes.
Where is that?
That is next. That is annexure 14, page 41. Paragraph page 48, paragraph 7.1. The finding. On the face of the.
All right, tell us what are the issues?
Yes, my lords. There was a regular post of district science supervisor was lying vacant in the district of Jajpur.
District
science supervisor post.
Science supervisor.
Yes.
Then?
The respondent 2 on 13/6/2017 directed all the district education officer of Odisha by following the rules you will be selected to the district science supervisor post. The respondent 3, by following the same, he has issued a direction to all the high school, government high school of Jajpur to place their science teacher for selection to the district science supervisor post. Accordingly, there was the DO has formed a district selection committee. In the committee, I have also applied with others. 14 teachers have applied, and in the selection committee, I was stood fast. Thereafter, when we come to learn that the respondent 4, the previous DO, before 2 days of his retirement, he has recommended the respondent 4 for approval to the respondent 2. The respondent 2, violating his guidelines, has approved the recommendation issued by the previous DO on 5/9/2023. That now after information I have received, see for the moment page 15.
In the page 50, annexure 15, the DO has given information that no such advertisement or letter for appointment of regular DSS was issued by the DO Jajpur and no teacher had applied for the post. Then 7. The name of this Kumar Sanapati was recommended to the DSC Odisha by order 26/6/2003 as revealed from the letter.
You are again relying on right information received under the Right to Information Act.
Yes, yes. And the respondent 3 said, and the respondents
Mr. Counsel.
Yes.
So whatever was the dispute was decided by this court in the earlier proceeding. Then why didn't you challenge that?
I have challenged mother that was dismissed, that is in the first case.
You challenged that by filing writ
Yes,
appeal?
in that case, I have filed a miscase for modification of that order, and that was rejected. I have challenged that order in the first writ appeal number 1398 of 2024.
So you challenge this order 4/1/2024.
Yes, in the WA number 1398 of 24.
So why did you file the second writ application?
Second appeal, because after disposal, I have sought for information from the respondent 3. The respondent 3 has supplied information that the respondent 4 has not applied for the set. There is an irregularities. There is no irregularities, and there is no committee.
So, Mr. Counsel, the court's decisions shall be altered on the basis of the information which you receive under the Right to Information Act.
No, the court directed the respondent to dispose of his representation.
This is something peculiar about,
No, mother,
this
this of the court directed to consider his representation. By considering his representation, he approved the recommendation. And the respondent 3 has said the respondent 3 office has not issued such a recommendation. There is no irregularity. There is no such file, or there is no.
So, Mr. Counsel, this is your submission that this court's order is illegal because of the information which you received under.
No,
the
no,
Right
I
to
have not said it
Information Act.
illegal.
This is what you're
I have said, my lord, the court has said that it is, you have not challenged.
So if the court records a finding
yes
on a fact, then you should apply under the Right to Information Act certain information as to whether that finding by the court is correct or not. And then you can challenge the court's order, or you seek review of the court's order on the ground that, see, this is the information received under the Right to Information Act. What is this?
Let's see for the moment.
All right, we will decide it.
Let's see for the moment, page 69, the court observed that the petitioner was also the petitioner W such and such. If the petitioner is agreed by the order of 4/1/24, it was open for him to challenge the same.
Point. There is decision
But
of the Supreme Court.
there is a decision of Supreme Court in 2005 that if a fraud has been
Fraud, forget. The information received under the Right to Information Act cannot be the basis for the courts to decide disputes. This is the law. And if that has not been held, that will have to be held.
Now, when a fraud has been opened,
all right.
And but this is a judgment I have citing that.
Just a minute. In the present case, a question has arisen as to whether the appellate can take advantage of certain information received under the Right to Information Act to assail an order passed by a judicial order passed by this court in a writ proceeding. Stop. The fundamental question is, as to whether informations received under the Right to Information Act can be the basis for adjudication of of disputes by courts of law. Yes. For the list this matter on 2 weeks. Who is appearing for the other side?
Government.
No, there's a private opposite party also.
Yes.
We will hear you on this point. Search it out. You are for the state.
I am for the state.
Please assist us on this point.
My lord.
But I given a judgment, but I have citation I given.
This citation is irrelevant. This citation does not answer our query. Not all.
Both.
Yes.
Item 11.
So item 11, one pass over me. One pass.
As requested.
Item 12.
May I please, Bilal? I am for the petitioner. Bilal, on the last occasion where I left discussing Bilal at the page number 25 of the impugned order, the last two paragraph of the page number 25 of that impugned order of lapsing. This is pertaining to a lapsing of a minor mineral lease. And then, my lord, in this order, at last but one paragraph, it has stated or given the observation. The state government has given the observation. Your lordship has it at the page number 25, my lord?
Yes.
Yes, my lords. The last but one paragraph, that's the observation of the state government. And whereas the lessee had not taken any steps for obtaining the environmental clearances, rather he had submitted part surrender application. The lessee had applied issue online on 31st of January 2017 and submitted the hard copy before the CR on 6th of February 2017 for obtaining the same. It proves the inaction of the lessee for obtaining the EC for commencement of the mining operation. In view of the above, the state government, after careful consideration, have been pleased to declare the mining lease of soapstone over 13.318 hectares of Mayurbhanj district granted in favor of this one so as lapsed with effect from the 31st May 2011 under Rule 26(9) of the MC Rules 2016. Now, my lord, this particular order of lapsing was issued pursuant to, my lord, the direction by the Honorable High Court in the WPC 4104/2016, that is at the page number 10678, where similar lapsing order has been declared as has been set aside by the Honorable High Court, directing them to consider my application not on the lapsing, but my application for part surrender of the area. So instead of deciding, my lord, getting into the problem of why I'm not operating, because this particular non-continuation of the discontinuance of the mining operation pursuant to direction of the government, that is at the page number 66. So it is not a case of a lapsing. It is actually not a case of a non-working on account of my demeanor or my misdemeanor. It is on account of the direction by the government pursuant to an injunction. That is a legislative injunction that unless and until you have all the clearances, my lords, then you can't operate the mining leases, and therefore it is not within the volition of a party. So the case at all not fall within the ambit of even the lapsing or no lapsing at all. And that's the legislative principle. And then your lordship may kindly turn to the section 4A4 for a moment on the last occasion. I have requested your lordships to go through the section 4A, subsection 4.
Yes.
Where the holder of a mining lease fails to undertake mining operation for a period of 2 years after the date of execution of the lease deed, or having commenced the mining operation has discontinued the same for a period of 2 years, which I fall within this second category, the lessee shall lapse on the expiry of the period of 2 years from the date of the execution of the lease. So therefore, my lord, the lapsing will automatically come in play when there is a event of a non-operation. Now, that operation, whether it is voluntary, whether it is through legislative injunction, now your lordship may kindly turn to the page number 66 for a moment, where they have directed me to suspend the mining operation. Page 66 follows. That the annexer 8.
Yes.
This is the letter issued to me and subject is working off so and so mining lease during verification of. Now this is the direction, and then my lord, immediately until getting all the statutory to run mine and submit to this office for a necessary verification as per the direction of the government of Odisha. Write their memo dated 1st of October 2009, failing which action will be taken for determination. So therefore, my lord, there is a direction for suspension of the mining operation pursuant to, my lord, the government of Odisha's directive to the all mining officer, that is 1st of October 2009. And then saying that if you do not suspend, obviously we will determine it. Of course, I am not supposed to run mining lease, my lord, without the compliance of all the laws. Then, my lord, your lordship may turn to the page number 106 for a moment.
Yes.
Here, my lord, this they have issued the lapsing order at page 101 and the disposition letter, my lord, at 103. Both of them is set aside by the Honorable High Court by this order. May I read with it for a moment, my lord?
Yes.
That the brief facts of the case at page number 106, the brief facts of the case are that the petitioner was granted mining lease so and so, continued mining operation up to 2009, whereas due to legal impediment, the petitioner held to suspend the mining operation. My lord, mark the phrase, my lord, the legal impediment. It's nothing with respect to the voluntary action of somebody is actually keeping the mining lease idle, for which the law of a section 4A4 can trigger. Because the section 4A4, my lord, is only with respect to somebody having all the clearances, having the legal entitlement to operate the mining lease, yet he is not operating it, and thereby keeping it idle for a period of 2 years, then only the provision of section 4A4 can trigger. It is nothing with respect to a legal injunction, which in fact section 4 subsection 1 also says no person shall undertake mining operation except in accordance with and under the lease deed issued under the act and rules, which, my lord, he has also been, my lord, declared by the Honorable High Court, Supreme Court from time to time by passing the order saying that without the clearances, no mining operation can be carried out. And therefore, it is not a case where I had all the legitimate, my lord, the documents for the purpose of continuation of the mining lease. And that is why this section, page number 66 was issued to me. I discontinued. With that cause of action, my lord, when this lapsing order at page number 101 and the 103, that is 2015, was issued to me at the page number 106, 7, 8, those two lapsing orders and the disposition order has been set aside. And direction were given to the government to consider my other applications, which were pending at that point in time. Now, in the meantime, there is a new rule came in, Odisha Minor Mineral Rules, 2016 December, pursuant to this order dated Honorable High Court. Then they have issued this, they have passed this order only on the Rule 26.9. Now, Rule 26.9 on the lines of the lapsing is the question for my lord's consideration as to whether the section 4A4 provision of lapsing is applicable, that is, somebody is discontinuing the mining operation, not for the volition part, but for the legislative injunction, whether we can ever get triggered. This is first and substantial questions for my lords to consider. And then the impugned order at the page number 25 is issued, my lord, despite the fact that my application also I have filed it at the page number. This is an application, my lord, at the page number O. if your lordships may kindly turn
Yes,
to the.
Please continue.
Yes, my lords. The application which I filed at the page number O, where it has stated, my lord, that page number, just a moment, my lord. Sorry. If your lordships may turn to the 22nd May 2023. Yes, 22nd May, my lord. Petitioner submitted all material documents as and when so desired by the opposite party number 2. Petitioner also submitted her representation 22nd May 2023 pertaining to the one last hearing of 7th of December 2021, hoping that the state will act in the just and objective and legal manner so that the petitioner can commence her mining activity at the earliest in consonance with their assurances. Then your lordships may kindly turn to the annexure 17 for a moment, which is
117.
117, my lord. This is my application, which is under Rule 26(9), requesting not to declare it lapsed. So, request for not to declare the so-and-so mine as lapsed. This has reference to the letter dated 17th of February 2010, wherein we were directed to discontinuing mining operation in the above mentioned mining lease of ours in obedience of the said order. The competent authority, that is the mining officer, we kept the mining operation suspended until date. We have not been allowed to resume the mining operation. In this regard, it may be pleased to note that soapstone has been declared as the minor mineral with effect from 10th of February 2015. Our above mentioned mining lease has not been declared as lapsed, neither under, and the order is issued by the Additional Secretary. Since the order is issued by the Additional Secretary, my lord, there is no appellate authority. And in any case, I have also written a letter, my lord, at the annexure page 20. Annexure 20 at the page number 121 and 22. It is yet to be responded, my lord. If your lordship will see the Rule 46, it specifies against which order who will be the appellate authority. And if your lordship will see the last, the substantive provision, last 3 lines. If the order is passed by the mining officer or deputy director, then the appeal would lie to the director. If the order is passed by the joint director and to the state government, in the case of the mines, if the order is passed by the director, here the order is passed by the Additional Secretary, my lord. So they have not themselves also exercised this protocol of the law of Rule 26. Had it been issued by the director, my lord, then perhaps the Rule 26, I would have the alternative cause of action, my lord. Recourse for appeal under Rule 46. Otherwise, there is no provision in Rule 46, my lord.
All right. Anything else?
Yes, now, my lords. Now, to sum up, my lord, that I have also, my lord, given a 2-page written note today, early in the morning, and with a list of dates, my lords, with the 4 broad grounds.
Yes.
My lord, my case is this, my lords. If your lordships may have that particular written note for a moment, my lord, it was sent through email. I also tried to connect to the.
You will read that. You are not required to read that.
Oh, please, my lords. Now, my lords, my proposition is this: that in the midst of an arrangement, my lord, the engagement with my partner, which state government is my partner, seeking solution to the problem, my lord, and host of actions from it, as legitimately expected inter alia from partnership. Well, the illegal impugned order is rendered in a clandestine manner. That's my whole submissions, my lords. Now to show that this order itself, apart from this, to show that this entire order, impugned order, is rendered, my lord, what are the illegalities of the order? The first, my lord, the foremost ground, my lord, that there is no opportunity of hearing is accorded to me. It's on the same line, on the last time also, my lord, in your lordship's previous order, 9th August 2016, it was also set aside because there was no opportunity of hearing. And this mining lease, my lord, was discovered by my husband, and pursuant to discovery of that exercise of prospecting, this mining lease was granted to my husband on and the lease deed was executed on the 17th of January 2001. He continued the operation of the mining lease till it was directed to suspend. That is on account of a legal injunction. Now, while I was exercising those the actions, then what happened, they have issued the lapsing order and similar lapsing order and disposition in December 2015. And that December 2015 lapsing order and disposition order was set aside by this Honorable High Court on the 9th of August 2016. And then host of directions were given to that of the state government. Now, those directions were to be complied with. And then in the meantime, my other applications are pending because my husband passed away on the 10th of July 2018. About 2 years later of this order, he passed away. While I have carried out all the exercises, the host of actions which I have undertaken, and those actions could not be materialized on account of the authorities themselves saying, since you are staring the lapsing order, even though the earlier lapsing order was set aside, but I was issued the notices, so-called notice on.
You are repeating, Mr. Das. Now you are repeating your submissions unnecessarily. So you cannot waste the court's time like that. You have already sent your written notes of argument. We will look into that.
Right, my lords. Now your lordship may kindly see the paragraph.
You are testing our patience, Mr. Das.
My lord, I am only saying.
You have made your submissions. You have sent your written notes of argument. We will look into that. We will pass appropriate orders.
My lords, may just kindly bear with me for a little more. My lord, give me 5-10 minutes, my lord. I will not repeat anything. Whatever I have submitted, I will not repeat anything, my lord. This is an assurance, my lords, as an officer, my lord. My lord, I say that the scope of section 4A4, I have given a provision and I have extracted that, and I have shown to this honorable court that when the impugned order at the page number 25 is rendered, relying to a different provision of Rule 26(9), and when my application for also not to declare it as a lapsed is not decided here, even in the impugned order, my lord, that's the second proposition I wish to humbly submit, that I have filed an application under Rule 26(9), which is at the page number below the 117, where 17 and 18, that is on the 20th of November 2019, where I have requested the state government not to declare it lapsed, and then your lordships may kindly turn to my annexure P20 for a moment.
Yes.
This is the representation, my lord, which I gave it to the state government on 5th of February 2024. When I received their letter, the impugned letter, that is the 1st of February, which I received it immediately on the receipt of this particular letter, I have given a representation. And also I...
Not Motor Vehicles Act.
Page number 121. And I'm referring to my letter, 20th of November 2019. If your lordship will see the reference.
Seen that.
Yes.
We have seen.
Now, your lordship will just kindly turn to the page number 77 for a moment.
Yes.
Well, my predicament is this. Actually, my predicament is this. Who on earth, my lord, can penetrate this in genuinely applied vicious catch-22 way without clearance? You don't issue order, while clearance can't be processed and obtained without your order. Then I have requested, my lord, 4 things, that kindly give me the copy of that reference.
Mr. Das, you are incapable of getting an environment clearance.
No, my lords, I'll tell you, in the meantime, there has been change in provisions, my lords. There has been change in provision. My application was pending before the state level authorities, because that's the reason why I was...
Please conclude now. Please conclude. We will not put any question. We are sorry, Mr. Das. We will not put any question. Please conclude your submissions.
My lord, I think I am failing in my duty. Perhaps that's why I'm not able to, my lords, your lordship's engagement. Yes. I'm not doing your lordship's engagement. That's something which, my lord, you're putting me in a state of a predicament, my lord. I therefore, my lord, then humbly request, my lord, permit me to withdraw it and then give it to the state government, my lord, if at all my application, in fact, my application of 5th of February, which is pending, your lordship may kindly direct the state government to consider that.
No, you may withdraw, you may seek whatever remedy, but if you want us to decide, we will decide.
My lord, then the proposition, then your lordship, then the pure question of law under this
Sir,
section.
we can assure you this much, that whatever proposition you have raised and whatever you have mentioned in your written notes of argument in your writ petition, we will deal with that and we will decide the case. Why are you, the choice is yours.
My lord, I'm so humbled, my lord, your lordship is giving me that choice. Then, my lord, in the
Yes,
meantime, then.
that we will decide, and that is our duty. If you make your submissions, if you have filed your pleadings, then we have a duty to decide your pleadings based on your submissions. We will decide.
My lord, then that is one option which your lordships have been kind enough to give it to me. The
That is
alternative.
not my option. That is we don't have any option. We have a duty.
Then, my lord, permit me to then lead those judgments, my lords, based on which your lordships can at least
We
decide.
will not adjourn. We will not adjourn. Our time is not our time. Our time is court's time.
My lords, then, my lord, permit me to at least approach the government, my lord, in the meantime, at least to deal with this, my lords, give me 6 months time, my lord. In the meantime, if I won't be able to get all those clearances which is pending.
We will not say anything. If you want, you do. We will not observe.
Just my lord, kindly just give me a small liberty, my lord. Just a small liberty to approach.
Liberty that can be given. Liberty
Yes.
can be given.
Yes, my lord, your lordships kindly give me the liberty to approach the state government under Rule 26.
On behalf of the petitioner, after the argument, seeks permission to withdraw this writ application with a liberty to approach appropriate authority / forum for the redressal of his grievances as raised in the present writ application. This application is disposed of as withdrawn with the aforesaid liberty. Yes.
My lord, direction may be given to dispose of my representation.
No. Yes.
Item 13.
Lord, I am in virtual mode. This is the nursing matter, my lord, which has been adjourned to 25th for filing myself the counter in all those cases. Let this be listed along with that. 15883 of 2024.
Yes. These are nursing matters.
Yes, my lord. Where the rejection has been issued and my lords have given direction to file the counter this week. This matter will come on 25th of July. So let this matter be also tagged with that.
25th. List this case along with WPC number. What is the number?
15883 of 2024.
15883 of 2024.
Yes, my lord.
On
25th. 25th.
On 25th of July. 25/7.
You are Mr. Mishra?
My lord, I am there.
Yes.
Harshiman.
Yes.
Item 14.
May I upload?
What is this?
This counter and regenter both have not come in the record.
Yes.
Yes, my lord, annexure base 14, annexure 1. My bid was rejected on the ground that I have not filed 2 separate affidavits. But the rule provides that an affidavit is filed, also shows the tender call notice also provides that an affidavit has to be filed. Now they have, my submission is, the lordship can see the eligibility conditions. The lordship for moment page 33. Page 33 in the entire date has been given by in the auction tender call notice. Page 33. The bid was invited on 7/3, my lord.
Your technical counter affidavit has been filed.
My lord, I have filed, say I filed counter, I have filed rejoinder also.
You have filed rejoinder. Counter affidavit, whether it is there?
They have not uploaded, my lord. Both the counter and rejoinder has not been uploaded.
You filed on the 9th?
Yes, your lordship.
In the present case,
You filed
5th on
you filed on 5th.
counter affidavit. has been filed on behalf of the estate online. So a rejoinder has also been filed to the said counter affidavit on behalf of the petitioner. On the top, both the pleadings are not there on, both the pleadings are soft copies of both the pleadings are not there on record. Though a hard copy of the rejoinder has been made available to us. So stop list this case tomorrow. Tomorrow with the counter affidavit filed on behalf of the estate. Okay.
15,
Lordships may, what I'm challenging in this writ application is, my lords, the CVC guideline stipulates that I should have 30% of the financial turnover of a particular, suppose I'm taking a contract for 10 crores, then I should have a financial turnover of at least 3 crores in the previous year. So accordingly, I can bid for that work of 10 crores. But my lords, in this present tender, what they have said is you bid, you need to have a turnover of 100%. That is what I'm challenging, my lords, because this eliminates competition. And my lords, when 30% is the CVC guideline, then my lords, why should they insist upon
So
100%?
CVC must be minimum. What is that?
At least. At least it's minimum. Yes, my lords. That I agree, my lords. But my lords, by this process, entire competition will be eradicated, my lords.
Competition, they, in fact, again, the employers are the best.
Yes, my lords.
Persons
Certainly.
to
What
decide.
your lordships is saying is correct, my lords. But my lords, this sort of turnover, most of the contractors, my lords, they will not
What is
have
the kind of, what is the nature of job? What is the
nature of road work, my lords.
work you need to?
My lords, only the big players can come in, my lords. The smaller contractors cannot enter into the fray.
They are more interested in their work.
True, my lords. What your lordship is saying, I'm not disputing. At least 30%, they say, my lords. That is the wording, at least 30%. CVC, guideline, my lords. Page 57. Footer. Yes, my lord. Should be at least 30% of the estimated cost. What your lordship is saying is 5A1, average annual financial turnover during the last 3 years ending 31st March of the previous financial year should be at least 30% of the estimated cost. That they say, my lord. What your lordship is saying is correct.
That is also correct.
Yes, my lord, sir. But my lords, this will actually eradicate competition. The smaller contractors, my lords, they will not be able to compete, my lords. That is why we have filed this writ application.
%.
30%. Earlier
Earlier.
practice was 30%.
Why is the change?
Policy decision, they are at the prerogative of change. They want the
Still,
substantial
there must
work
be
here.
some rationale.
Quality work, your lordship.
Quality work, but are you of the view that the earlier works which were done were not up to mark?
Lordship, the government has come up with this decision.
Do you have?
This,
No, Your Lordship, I have to take
Why they have done it?
to take instructions. Your
Like you are presuming, we are also presuming that it must be because of that, but what is the rationale?
All you file your affidavit.
I'll file.
obliged.
Time is allowed for the state to file counter petition. The bidding process, I'll however continue in the amendment. Bidding process in questions, I'll continue. Yes.
Obliged. Well, maybe no final decision. Obliged.
16.
Ms. Patna, I get it within 4 weeks.
Yes.
Yeah, please, Your Lordship. Your Lordship, I just brief the facts of the present petition, Your Lordship. That the petitioner was in the first technical round, he was declared as a qualified bidder. And after that, based on a grievance of a rank outsider, there was a grievance committee which was formed by the OP number 3, wherein behind the back, they conducted all the procedures. There was no intimation regarding any of the procedural aspect to me. They have never communicated. And after that, they have come up with a decision of disqualifying me. If Your Lordship may kindly have the tender notice at page 18 first. Yes. If Your Lordship may see, name of the work, serial number 1. If Your Lordship may see, it is OR 24-123 and OR 24-51. This is the work for which I have bidded. The present work under challenge in this writ petition. Thereafter, Your Lordship may have page 225.
So from 18 to 225.
Lordship. At page 225, under serial number 3, if Your Lordship sees, is the same work, name of the work.
Yes.
And under 4, Ridham Agarwal, I have been mentioned as a qualified bidder.
Column 4.
Column 4. Under the serial number 3, column 4, Ridham Agarwal, bid status is qualified.
Yeah.
If Your Lordship may turn to the next page, 226.
Yes.
If Your Lordship may see, under the same column, they have disqualified me, making a remark that separation of data as per clause 47.1 of DTCN.
So what is 4.7 of DTCN?
Your Lordship, it is with regard to suppression of any material facts.
What is that? So which material was suppressed?
Lordship, they allege that one of the rank outsider, what he alleges that I have not submitted a details of the existing work commitment which I have. If Your Lordship may have page 227 for a moment. The proceedings of the grievance is there at page 227.
Yes.
Grievance put forth by Shri Bijay Kumar Babu. If Your Lordship may kindly mark this name, Shri Bijay Kumar Babu, that the petitioner is not a participating bidder in this work, alleged against the bidder Shri Ridham Agarwal. In their own order, what they say is that this petitioner is not a participant bidder. And if Your Lordship may for a moment kindly have page 39 before I to proceed with.
Yes.
Lordship, under the clause 22.6, the result of evaluation of part 1 bids of the bids shall be made public on e-procurement system, following which there will be a period of 5 working days
during which any bidder may submit complaint which shall be considered for resolution before opening of part 2 of the bid. And here, your lordship, in the same impugned order where they have disqualified me, they themselves agree that he is not a bidder. And your lordship, the moot question here is, if he is not a bidder, the complainant here is not a bidder, then he cannot have access to the documents which I have submitted. And the same has been pointed out in my representation, which I have sent at page 200.
But suppose they have some information.
That is reflected in page 227.
Page 220?
7 that proceeding itself.
That if they have some information and no objection is raised by any bidder, then they cannot take any action.
Lordship, there has to be some basis, because here what has happened is, because there was a complaint which has been made by a rank outsider.
So this is what we are saying, that had there been no such complaint by any person,
Lordship,
but the evaluation committee could have some information, then whether on the basis of such information the committee could have acted on.
Lordship, for that also the principles of natural justice has to be followed. They would have to provide me an opportunity as to they should make like issue a show cause.
They should have.
They should have issued a show cause.
They should have given that opportunity.
That opportunity.
We are giving you that opportunity.
Lordship, it has not been. If your lordship may kindly have 229, under the same I have made a grievance on the same date, and thereafter lordship on.
No, whether the findings are factually correct or not is the
lordship
only.
The findings are factually correct.
Then
lordship, but the predicament is that they have first of all is that the complainant.
If the finding is factually correct, then why should we interfere?
Lordship, may kindly just have that. First of all, the complainant is not a bidder. Okay, he cannot have access to the same. And thereafter, once they have disqualified me under 229, what I have also made a grievance stating that the other co-bidders who have participated in the bids, they have also made material suppressions. And that has not been considered, and the same representation was disposed of, stating that you are time barred. The predicament is this, my lords, that not only me, but all the bidders, they have made suppression. And only I was subject to the same. And when I raise a grievance, then they say that it is time barred. If your lordship may have, just have 242. Last paragraph. Meanwhile, your representation has been received on 27/6 through official mail with a letter Neil 26/6, alleging that other bidders, since there is no provision, other bidders, they have not mentioned what is the allegation itself. Since there is no provision in the SDP to conduct grievance redressal committee after opening part 2 of the bid, that is the financial bid, since your petition received much after the first technical qualification result, allowing 5 days, your representation cannot be considered at this. If your lordship had the occasion to go through the clause 22(6), there it doesn't mention, your lordship, that it is with regard to the
So
first.
that is C. So far as allegations against on the basis of finding which has been reported, you may be blacklisted,
Well,
lordship, but I have also made a lordship. The predicament here is now that I was also not provided an opportunity for filing agreements, and then
therefore we said that we are giving you that opportunity. If you satisfy us that the findings are incorrect, then we can interfere. If otherwise, if it is admitted that the findings are correct, then what is the use of going through that formality of issuance of so-called notice or anything?
Lordship, but the predicament here is that I have also made a grievance on 26/6.
Yes, and it was hearing, yes.
Let's say, kindly see page.
So far the first aspect is concerned,
Mile.
so far the finding against the petitioner is concerned, he has very fairly
Mile.
stated
Mile.
that he cannot defend those findings against him.
Lordship.
But his grievance against other bidders, so you have not considered because there was time bar.
Mile.
So someone who was not eligible to make a complaint, his complaint has been entertained.
Mile.
And his complaint you have rejected on the ground that it was time barred.
Lordship, kindly see his prayer, my lord. He is not challenging this order.
No, he may not be challenging
My
that order, but the question.
In fact, my lord, your lordship, kindly see the
fact has come to our notice.
lordship, kindly see the provision at my lordship 226, 22.6 for a moment, my lord. 22.6, page 39. You have lordship already seen, my lord. Because of 5 days time I have given, my lord, for lodging a complaint.
For raising a complaint against by?
Raising a complaint against the rejection of technical bid, my lord.
By?
By the bidder, my lord. He is a bidder.
So in his question, you
15.3,
consider, in his case, you have considered the complaint of somebody who is not a bidder.
My lord. And 15.3 technical bid was rejected. And
Lordship,
he submitted his complaint on 26.
So your complaint was not against the other bidders. Your complaint was against your disqualification.
My lord.
Both, my lords.
There is point out that specific thing where you have
Lordship,
stated.
if the lordship, one factual aspect. Lordship, under page 225, I was declared as a qualified bidder on 15/3/2024. And under page 226, I was disqualified on 26/6/2024. It is not the case that I have come belatedly, because on 26/6 is the date when I was disqualified. And on the immediate next date only I have made a representation.
No, disqualification does not give you a cause of action.
Lordship, because it was the technical bid which was uploaded again. The result of the technical bid was published again on 26/6. Because until your lordship on before 26, I was declared as a qualified bidder.
My lord, when he was declared as a qualified bidder, Annexure 7. He is challenging only Annexure 4.
Annexure 4.
Annexure 4 is his rejection, my lord. Page 2 to 6, my lord.
If your lordship, that is prayer A. The prayer B and C also has to be considered. What I have prayed that direct the
No, but Mr. Agarwal, what is your objection? You have made a general objection.
No.
See, page 229.
is 229. If you read shipment.
Yes, I'm looking
But
at that.
from the fourth line, but other bidder, namely Sri Gopal Charan Sahu, Vijay Kumar Sahu, and Sri Ram Kumar Sahu, has also separated their existing commitment. The date of the commencement are so work orders. And on the next page, from page 231, I have also attached the work orders in favor of them. No. And in the same, while they have disposed of the same, they have not considered it.
No. application number BPT/online 49/2023-24 dated 3/2/2024. Full stop. The impugned order has been brought on record by way of annexure.
Mixture 4, man.
Annexure. No, impugned order.
Seven.
Annexure. No. 7 to the writ application, which is apparently based on an information received from one Vijay Kumar Babu, who was not a bidder. Complaint to the information we have regarding suppression of work in hand by the petitioner while submitting his bid. Full stop. He is said to have suppressed. What is that requirement?
Work in hand, my lord, he has to disclose.
Disclose
in
the
hand, he has to
existing work
disclose.
commitment.
Where is that?
Clause 22.6,
No,
No.
page.
Suppressed his existing work commitments, which he was required to disclose while submitting his bid. Full stop. Next. Then counsel appearing on behalf of the petitioner has submitted
4.6 million.
that
No.
the respondents illegally acted on a complaint made by a rank outsider who was not a bidder. First off, he has drawn this court's attention to clause 22.6 of the bid document. What is that page?
39.
To contain that on our attention to clause 22.6 of the standing bidding document, which reads as under standing bidding document for maintenance of PMGSY roads, which reads as under 2.6 quote unquote. He has submitted that as per the said provision, only a bidder could have made a complaint which could be considered for a resolution before opening part 2 of the bid. Full stop. He has further submitted that before impugned rejection, the petitioner was not given any opportunity of hearing, and therefore the impugned action is violative of the principles of natural justice. First off, he has thirdly submitted that the petitioner had made similar complaints after his after the rejection of his bid to the authorities against other bidders, other qualified bidders who had also made similar suppression as alleged against the petitioner. So he submits that acting arbitrarily, the petitioner's complaint has been rejected on a hyper-technical ground of being time barred. Whereas there was substantial substantial material against the other qualified bidders to the effect that they had suppressed the fact about
Their existing work commitment.
their existing work commitments. So, next, learned counsel representing the opposite party / state of Odisha has submitted that learned counsel for the petitioner has, however, not disputed the finding as regards suppression of existing work commitment found by the evaluation committee.
Lordships.
By the evaluation committee against the petitioner. So stop. Next. State council. For the state. Has submitted that that in accordance with clause 22.6 of the bid documents, the petitioner being a bidder, could have raised could have filed a complaint within 5 days against other bidders. First off, since he failed to do so and made the complaint after a rejection order was, impugned rejection order was passed, his complaint was rightly rejected by the evaluation committee as time barred. That is your submission. That's all. Next. After having heard learned counsel appearing on behalf of the petitioner and learned counsel, learned AGA representing the state of Odisha, we are of the view that the impugned rejection order does not require impugned decision to disqualify the petitioner, does not require interference in view of the admitted fact that the facts regarding existing work commitment were suppressed by the petitioner. Full stop. It is true that clause 22.6 of the bid documents authorized the bidders to make complaint against any of the other bidders, but the evaluation committee was not unauthorized to consider complaints received otherwise regarding suppression of material facts. So stop. We would have gone into the question of violation of principles of natural justice. But in view of the admitted fact as noted above, we are not inclined to entertain the challenge to the impugned order on the said ground. So, next. However, we are of the view that the learned counsel for the petitioner has, however, emphatically submitted that the other bidders suffer from the similar disqualification and specific complaint was raised by the petitioner in that regard. First off, we are of the view that once the evaluation committee opted to consider a complaint received from an outsider, it could not have rejected complaint of the same nature made by the petitioner on the ground of the same being time barred. First off, in the time barred. First off, they ought to have at least looked into the question as to whether the other bidders stood disqualified on the count or on the ground of suppression of their existing work commitments. First off, with the observation that the competent authority shall look into the petitioner's complaint in the light of the observation, in the light of the opinion as noted above, this writ application stands disposed of.
Lordship, if I may humbly pray that as per your Lordship direction, unless they make any further observation or order, till that time the third party interest that may be protected.
In tender matters, Mr.
Lordship, because LOA has been issued to OP number 7 in this.
Maybe the petitioners will be at liberty to take recourse to any action as may be permitted to him in accordance with law.
Right.
So you had made complaints against 3 bidders.
3 bidders, all the 3 qualified bidders. And now the OP number 7 is.
Right.
Lordship.
3 bidders, 3 bidders.
Obliged.
Item 17,
Complied.
Here, my friend has filed an affidavit raising objection to the compliance because here. Last occasion, I had filed a document saying that his case was earlier considered by the land acquisition officer and his case was rejected. Lordship wanted asked me that he is not the authorized person because there was a direction to the director before whom the documents were submitted. He considered the documents and found the petitioner to be below 18 years of age and accordingly rejected the claim because he said that he is not entitled to benefit. Now, for a friend has filed an objection. Lordship. I want to go through it, Lordship, if necessary. Lordship, call it. I will.
Let us see the order first.
Yes, Lord.
Yes. Running page 9 yours. Contempt application.
Yes.
Operating person is running page 10, paragraph 5 of your Lordship's order. The order is for payment to the displaced persons. Like the petition.
And proposal which was submitted by the land acquisition collector was objected to by a law person saying that fraud has been committed not in respect of these petitioners. Many cases
where no documents have been created to get those. Accordingly, an inquiry was made, and I have given those documents, about 5 documents, date so far, date of birth of the petitioner concerned, Anganwadi worker register of village dog and source 76,
All right, please
1997.
come to paragraph 5 again.
Yes.
With a direction to the director from additional secretary to the government to sanction the proposal submitted by the collector. So whether that proposal has been sanctioned or not.
He, while dealing with the same, he found that the proper sanction which has been recommended by the collector is fraudulently made. That is why he has passed order saying that it is a fraud has been committed on the collector, and 5 date of births have been given by the petitioner, and he is not, he is less than 18 years. That is why he is not entitled to the benefits of R&R. His benefit of compensation has already been paid to the land losers. And
So
5
what
date
does
of
he,
births.
what more does he want?
He says that it's not in consonance with the order of this honorable court, so he has
So
raised
what
the
does he want? The petitioner wants.
Madam, that the rehabilitation assistance to the displaced families.
So what is that assistance?
Assistance, your lordship,
Compensation or appointment?
compensation. Quantum of compensation, 2 lakhs, 3 lakhs. Or
It's ex gratia. Compensation has been paid.
So what more do you want?
my lord,
What more do you want? You have been paid how much?
that the quantum was the quantum was quantified, indicated that
How
8
much?
8,26,000. Thereafter, the collector and the land action officer, as well as the tahsildar, as well as the BDO, the all 5 officers are made inquiry about the matter and found the petitioner as entitled to get the compensation of rupees 8,26,000. Thereafter, the collector sent the same proposal to the director for sanction the amount and payment. In spite of that, the processing of delay, the petitioner approached before your lordship directed to the director to sanction the amount for payment of the said amount, 8,26,000 to the petitioner. In this regard, I filed my an affidavit, your lordship. Your lordship may submit.
No, but see, these were the questions of facts you alleged in your writ petition, and they did not have any opportunity to reply. And now we are required to proceed against them for contempt.
Your lordship has directed to
There
the
is
director
question
to
of
sanction the
direction.
amount.
See,
But-
had there been any counter affidavit filed in this case, the matter would have been different. They could have taken a stand that this has been obtained fraudulently.
Your lordship may I file an affidavit, your lordship can see.
What is the question of affidavit? See, this order was passed on the very first day.
Yes.
No notice to the estate.
Yes, your lordship.
No counter affidavit.
Yes.
And now you are saying this. In contempt proceeding, we should punish them.
Yes, your lordship.
We are not inclined. The
liberty to manage.
Yes, petitioner has.
Your lordship, liberty to challenge this.
For the petitioner, after some argument, seeks permission to withdraw the present contempt application with the liberty to pursue his remedy before appropriate authorities / forum in accordance with law. This contempt proceeding stands dropped accordingly.
Liberty.
Liberty has
we
been
have-
granted. You are not listening, that is why.
Liberty we have given. That we cannot take away. You're right. We are equally concerned about the rights of the people.
Because the document which has my lord senior, I have not got.
He'll give you.
18.
Listen, item number 18, lordships were pleased to grant me time till today, lords, to comply the order. Lord, so far as I filed an compliance affidavit stating that, lords, as per the direction of this honorable court, the gradation list has been already been prepared at the state level. It has already been sent to the district, all collectors to lords comply the order. Even on 6/7/2024, the contemner has directed all collectors to comply your lordship's order. As
Where
per
is the order?
My lord, your lordship may kindly see order number 5. Last
No,
order.
not order number 5. What is the order?
Original law.
No, 6/7/2020.
Page 37 in my contempt petition. That's the order. Para 7. Still,
Paragraph 7.
yes,
Whether this has been done or not.
this has not been done till date. And that is why your lordship passed on 26 June, order number 5, calling upon them to fully comply the order. Otherwise, there will be personal appearance of the opposite parties. Your lordship may kindly see order number 5. That is the last order.
Yes, but are they present?
Yes, no, so far as this main contender is concerned, he has completed his part. He has drawn the gradation list district wise, and he has already communicated to all the collectors, because they are now, it has become a district cadre instead of state cadre. Now the collectors have to act and give promotion. That is why we once again on 6/7 he has directed the collectors to comply with lordship's order.
No, there is no requirement. We shall proceed against him because that order was passed in 2023.
Yes.
We are in 2024. Contempt has already been committed. In this case, we are proceeding against this officer.
The first part of the order you complied.
Yes,
There are
please.
2 parts to this
No
order.
parts. So far as giving promotion is concerned, promotion has to be given by the concerned collectors, not by the present contender who is the labor commissioner. Because the posts have now become a district cadre instead of a state cadre. Accordingly, he requested.
Second part it is said.
No, when that became, the post became a state district cadre.
Your lordship judgment order was passed. Prior to that, when your lordship directed that the state gradation list shall be complied by the labor commissioner, and accordingly it shall be sent to the district authorities, and the promotion shall be given. He did it. Now it is pending with the collectors. So if some time given, because
No time given. We are initiating contempt proceeding. We are initiating contempt proceeding in this case. No, but still, it was in 2023.
With notice or without notice? Was it disposed of on the first day or thereafter?
no, I think not so. Same day disposal.
No. Several opportunities were given.
Count was failed.
The state was given full opportunity.
We are initiating. We are satisfied that this court's order dated (29/8/2023) passed by a division bench of this court in WPC number 8657, 8545, 8649, 8653, and 8659 of 2023 has not been complied with so far. So, the inaction, a compliance affidavit has been filed by one Vijay Amrut Kulange, presently working as the Labor Commissioner, Odisha. Full stop. He has stated in his compliance affidavit that after he joined as the post of Labor Commissioner on 15/4/2024. Full stop. In the compliance affidavit, he has discussed the steps taken by him for implementation of the court's order, violation of which has been alleged in the present contempt application, operative portion of which reads as under at page 27, paragraph 7. Full stop. Today, a copy of communication dated 6/7/2024 has been placed before us, written by the present Labor Commissioner to the district magistrates.
Yes, all collectors come district
to
magistrate. At
the
the
all
bottom,
collectors and district magistrates of Odisha to take immediate steps for consideration of promotion of junior assistants in accordance with the prevailing rules for implementation of the High Court's order so as to avoid any further adverse proceedings by this court. Stop. Next, though after having gone through the compliance affidavit filed by the present Labor Commissioner, that is Sri Vijay Amrit Kolange, as regards the steps taken by him for implementation of the order, violation of which has been alleged in the present contempt application. We are prima facie satisfied that his predecessors bracketed slash had not taken immediate steps to properly implement the court's order dated 29/8/2023. First off, we are accordingly of the view that contempt proceeding is required to be initiated against erring official bracketedness. First off, let an affidavit be filed on behalf of the filed by the Labor Commissioner Odisha, stating the name of the person who was holding the position of Labor Commissioner Odisha as on the date of passing of the order dated 29/8/2023.
they are already on record. 1 and 2.
Subsequent thereto. Full stop. The list this matter on 4 weeks when the court will consider as to whether the collectors of the different districts are to be impleaded as contemners in the present proceeding or not. Stop. Four will.
19.
May I please your lords. Last order dated 20th June 2024. Your lordship prima facie satisfied that opposite party contemner had violated this honorable court order, my lord.
Yes.
And
Last occasion, the lordship look at, I had given a letter to a lordship.
Where is the order?
My lord, order is at page 14, my lord.
Lordship, may I draw your lordship's attention on
Page-
11.
Just a minute, just a minute.
No.
Page 14, page para 8,
Para 8.
my lord.
There is no para 8. Page 14.
My lord, 1-4, page 1-4, 14, para 8,
Yes.
for all purposes.
So the para 8 has been implemented.
No, your lordship, on 10th, I produced a letter from this authority to the petitioner to submit his mark sheet. That is why lordship adjourned this matter to submit him, and that must be on record of lordships, the letter where he was directed by the lords.
I have submitted my mark sheet.
Then I will take instruction because the lordship wanted that he should submit his mark sheet and accordingly order will be passed. Lordship may take it up 2 o'clock, I can obtain instruction. Lordship look at your lordship order 11-7. On 10th, I produced this letter and lordship wanted him to submit the documents.
No, but Mr. Samantra, you must observe that your officers are taking the orders.
That is true, lordship. I don't defend them, lordship. They have not complied, lordship, in letter and spirit. There has been inordinate delay.
No, then they must be conveyed properly by judicial orders.
You will also take it up 2 o'clock. I will get information.
Please inform us. Otherwise, we will initiate contempt proceeding in this case also. This is not done. This is of 2023 order, and the specific the function which was required to be done by the executive, that has been done by the High Court.
Right, no, that is true.
Please place him at serial number 5 because of his marks. Give him appointment. Everything. And we are in July, and you are saying you will have to seek instruction. Why should you? Why he will not give you mark sheet? If he doesn't give you mark sheet, you will not implement the
we have
court
to act
order.
in accordance with the lordship
Please,
direction. That
please, otherwise that too we will initiate contempt proceeding.
Lordship, take it up 2 o'clock. Whether it has been, I will inform. Otherwise, lordship.
Please do it. And Mr. Samantra, after all, this is wastage of the court's time.
Right, lordship.
We pass orders and then we waste time for implementation of our orders. This is too much. We'll take up at 2.
Yes. They mark sheet on the basis there, they will take only 2-3 days. Now they've said, I will leave to lordships because enough time I have.
Then I leave it to Mr. Counsel.
My friend, what
If you can convince him, then otherwise,
My lords will.
as jointly requested, list this matter on 1 week. Stop on the next day, the court will consider initiation of contempt proceeding if by that date the order is not shown to have been fully complied.
I plead that this contempt petition has been filed for non-compliance of your lordship's order dated 2/11/2020.
Mr. Sahu,
Yes, ma'am.
Mr. S. Sahu is your associate.
Yes, sir. Yes.
He was making a submission before recess. So he was addressing us in a court, in a case before recess. We are very impressed with his submission. That is why we wanted to tell you. Which year has he joined?
This year,
This year. That means he's a
Only two.
pass out of this year.
3 months back.
Very good. All right. Oh, he's here.
There
Okay.
is another Sahu also. No.
Another
C
Sahu.
Sahu.
C Sahu. No, here we found S Sahu.
No, she is also a practicing lawyer. No. Daughter Mr. Sahu is also a practicing
So
lawyer.
he is
Son.
very good. And daughter is SS Sahu or C Sahu? Daughter.
The daughter is SS Sahu.
SS Sahu, not C Sahu.
No, I said she. Well, to
She.
mean that,
Okay,
yes.
okay, okay. All right.
She.
Okay. Is he willing to work as a research assistant?
He was, in fact, he was a research assistant when there is a debate in Karnataka state because he was studying in Bangalore. So therefore, he stood first in the research.
No, that is why we are giving him an offer.
As your lordship, please.
Then give your biodata.
Sure.
Let this petition that is against your lordship, for non-compliance of your lordship's order dated 2/11/2020.
It is not that someone will compel you to continue for the entire thing. Whenever you want that is not worth, you can leave that, but you should get this opportunity.
Pleasure.
And we also want to get this opportunity of your assistance.
Yes.
But your lordship can see that there was this PIL was filed.
No,
for
where is the order?
correction of a road. Milord, order is on 2/11/2023. I have annexed to at page 7, Milord.
Yes.
Of the ordering portion is at page 9.
Yes.
The last order, that was a.
What is the order?
That the order is for construction of a road to a pond at Gopalpur, and your lordships directed that should be completed within 3 months.
All right. What have you done?
Nothing has been done.
Municipal corporation, they filed a
Municipal
review. It has
corporation-
come along with your lordship board.
But where is the
They've-
council?
That the
Corporation has filed a review of that order. That is also listed before lordship today. But the council for the corporation is not there. We are not there, not only corporation is there.
on the previous date, they have made a submission that we have filed a review petition. So therefore, your lordship tagged that review petition with this contempt petition, but today they are not appearing.
Personal. There's no
That
council.
only-
No council is also present on his behalf.
No. I think Mr. Naik was appearing last
Yes,
Saturday.
That
Devasis Naik.
Devasis Naik was appearing in the writ petition.
No, this has also been filed by Mr. Naik. Review has been filed by him only.
Senior counsel is appearing. His name appears.
Pradipta Mama.
Yes.
Yes.
They have admitted before this honorable court that they will complete the construction within.
No, that is not the question. They have filed a review application.
Yes, ma'am.
See, the biggest problem with us is that these orders are passed on the very date of filing of the writ applications.
No,
So
sir.
whether any counter affidavit was filed.
No, they have filed the government filed the counter affidavit.
Government
Thereafter,
filed the
we
counter
filed the
affidavit.
additional affidavit and it was hard. Thereafter, this order was passed.
All right, where is the writ petition?
But the writ petition, your lordship. That will try.
Whether in the writ petition, the municipality was a party, municipal corporation.
Yes, my lord. Municipal corporation was a party and the government filed the counter that is representing opposite part number 1 to 4.
The government filed the counter.
Yes, my lord. Government filed the counter by saying that that is not possible because two private plots are intervening. So therefore, the private plot owners have given consent that I will leave the portion upon which the road is to be constructed.
Mr. Whether any affidavit was filed by the Cuttack Municipal Corporation?
Cuttack Municipal Corporation did not file any counter, but on the date of hearing, a submission was made because that was the impediment and that has been cleared. Now, there is no impediment for construction of the road. And that has been recorded by this.
What impediment?
But impediment was that connecting the road to the pond, there was two private
All right,
plots.
What? Yes.
Two private plots. The private owners file the affidavit before this honorable court that will leave that portion upon which the road is to be constructed. Because it was recorded under the Kisam Jalasaya. So therefore, it was converted to Gharwadi. They have converted to Sarada cultivable land. And thereafter, the order was passed by this honorable court that since there is it has been converted to Sarada 2. So therefore, there is no hurdle for construction of the road. And they have given the consent for construction of the road. But in this background, the council appearing for the municipal
Have you filed
corporation.
your affidavit pursuant to the review application?
I have
you
not
filed any
filed because the notice has been issued on the review.
File your affidavit. We have
Yes, madam, we will file.
Let counter affidavit be filed on behalf of the writ petitioner in RP WPET number 54 of 2024. Within 4 weeks, these matters on 4 weeks.
None appears on the petition as well, review petition.
None appears. Yes. All right.
22,
During this case, this applicant before the respondent before my lord is imbue and he has been joined in this job contract establishment. Therefore, subsequently, he has been regularized, brought to regular establishment in 1993. Therefore, 2003, he has retired from the service. And claiming pension, he has approved this level. And honorable my lord citizens, referring the judgment of this court as a listed appeals court has directed to pay compensation.
You are the appellant.
And challenging.
You are the appellant.
Well, I am the appellant in the writ and the respondent in this recapping.
So you will start your submission first. He is the people. He has right to begin.
My lord wanted from me that.
From you.
Yes.
Yes.
This is regarding the counting of total service rendered under work charge establishment, sorry, job contract establishment. Relying on judgment of this honorable court in similar case, this order has been passed. And a number of repeats we have preferred writ appeals, and those writ appeals were also dismissed on the ground of limitation. Against that order, we have approved the Honorable Apex Court. And Honorable Apex Court, why we are denying that benefit, we have granted the minimum pension in accordance with the Odisha Civil Service Pension Rules. As per the Odisha Civil Service Pension Rules, they are entitled to minimum pension. And the Honorable Apex Court, in the meantime, has issued notice and also stayed the order.
And also Honorable Apex Court has noted down our contention. Yes, so what should we do? Let's keep the matter pending for some time after disposal of this, so that matter can be decided.
He's getting minimum pension.
He's getting minimum pension, there is no dispute about it, because that rule says any shortfall that will be taken into account. The minimum pension 10 years. Suppose he has worked on a regular basis for 6 years, job contract 4 years, that will be taken in 4 years will be taken into account for qualifying as minimum pension. But his fair count the entire job contract period.
Okay, so the shortfall period will be taken
Yes.
for minimum pension. Okay.
That is the rule 18(6) of the pension rules. Learned AG appearing on behalf of the appellant has brought to our notice an order passed by the Supreme Court dated 29/1/2024 in SLP C number 2146/2024, arising out of a judgment and order dated 2011/2023, passed in WA number 1134 of 2024. Full stop. The said order reads as under. Pure order. Full stop. The question which is under consideration before the Supreme Court in case of State of Odisha versus Sudhanshu G.S. Sekhar Jaina is involved in the present intra-court appeal also. Stop. List this matter on 8 weeks. Awaiting 8 weeks. That is after disposal of SLP soils. Well, it will come after disposal. Well,
23,
3 minutes. In this case, I have already.
yes.
In this case, Millets, on 17/5/2024, Millets, the Lordship was pleased to issue notice on the question of limitation, Millets. I am appearing for the sole respondent, Millets. I have already entered my appearance. Let my learned senior serve me a copy of the writ application so that I can file my objection to the limitation petition file.
What is the delay?
The delay is 339 days.
And what is the point?
Point, the writ petition filed by the petitioner claiming regularization of service has been disposed of in terms of that Patita Pavan Dattadas case. Now, my lord, in similar set of matters where the writ appeals have been, writ petitions have been disposed of in terms of Patita Pavan Dattadas, your lordship have passed this order. Lordship only directed to keep the proceedings, the same order, similar order has been passed in the present case also. Page 48 is the impugned order. The lordship will look at the same.
The delay has not been condoned, my lords. No, only submission that the delay has not been condoned. Let me be given one opportunity to file objection to the limitation petition. If the delay is condoned, then the similar order can be passed. That is what my only prayer.
As requested on behalf of the respondent, 3 weeks' time is allowed to file objection to the application seeking condonation of it. In this case, 3 weeks.
Say copy of the writ appeal may be submitted.
Let copy of the writ appeal be served upon learned counsel for the respondent for him to consider the grounds taken in the writ appeal to assail the order passed by, impugned order passed by the learned single judge.
Grateful.
24,
Before, here, my lord, there is a delay of 169 days. The point is, my lord, the writ petition, the respondent was allowed only on the ground.
Yes.
Writ petition was allowed only on the ground that since the family of the deceased father has received the family pension, so the application of the petitioner for benefits under the Rehabilitation Assistance scheme should not have been rejected. Now, why the Honorable Court has given such finding? Because there is the father of the petitioner, the respondent, went on missing for more than 7 years. So, presuming to be as a case of civil death, the order has been passed. Now, my lord, so far as the family pension is concerned, there is a provision under the rules that in case of if a person remain untraced for some years, then he will be entitled, the family will be entitled for the family pension. But so far as the civil death is concerned, my lord, there is no such provision in the OCS pension rules. OCS pension rule is silent about that. Now, my lord, even assuming for the sake of argument, my lord, that there is a civil death, although there is no such declaration by the civil court, no such document was produced before the Honorable Court that the civil death has been proved by declaration from a competent civil court. My lord, even assuming that there is a civil death, still then there is a delay of more than 12 years. The person concerned has filed the application approaching this Honorable Court.
IA 7422 of 2023. This IA has been filed for dispensing with filing of certified copy of annexure. Certified copy of impugned order dated 1/3/2023, annexure 3 to the writ appeal. Yeah. For the reasons stated in the application, we are inclined to dispense with filing of certified copy of the order for the time being. The IA is accordingly allowed and disposed of. Next is IA 7423 of 2023. This IA has been filed for condemnation of delay of
169 days.
This seems to be 189 or 159. We'll check. I mean, the writing is not clear. 9 minus 3, 7, 189. 189 days in filing the writ appeal. Issue notice to the respondent slash, how many opposite parties or respondents?
Sole respondent.
Sole.
Sole respondent.
Sole respondent slash opposite party number 1 in the matter of condonation of delay. Requisites for which shall be filed within a week. List the case after 6 weeks. List the case after 6 weeks. 6 weeks of date. Yes.
25.
In 25, your lordship has issued notice on 16/5/2024. The question of limitation, there is a noting.
Nobody has appeared.
Yes, my lord. Noting item delivered.
All right, just checking which date. Returnable date. Let me see what was the return date. Fixing 11/7. So let us give another date. The returnable date was fixed at 11/7, which was last Thursday. Office note indicates that although neither AD nor unserved notice is returned from the sole opposite party, but the postal tracking report indicates that the item has been delivered. Full stop. Since returnable date was fixed to 11/7/2024, comma, list the case on 23/7/2024. Full stop. Registry to ascertain if any counsel has appeared on behalf of the respondent. Yes.
26.
26, my lord. 26, I am appearing for a respondent number 1, my lord. Filing objection delay of 466 days delay, my lord.
No objection.
Giving
466.
So do you have any objection to the limitation petition?
My lord.
No. Do you have any objection or will you condone the delay and hear it on merit? Because you will be heard. So what are you saying?
Objection on delay, my lord.
So you have filed?
My lord, I am just now.
What is this matter about?
Matter is claiming the petitioner was initially appointed 1974 as a job contract employee, then brought over to the regular establishment, my lord, on 2010. Now from 74 to 2010 and until his retirement up to 2014, he never claimed for regularization of his entire period of job contract service, my lord. Now, after 8 years of his retirement, he approached this honorable court claiming that my entire job contract period to be taken into consideration for the purpose of regularization and pensionary benefit. Now, so far as the rule, the pension rule is concerned, the 18(6) is very much clear that if somebody, the job contract.
So we will have to apply 00 rule.
In similar case, 323 days delay, my lord, your lordship not condone the delay. 320.
We have condoned the delay?
No, not condone, my lord.
Let us see.
This
Similar matter.
in delay.
Similar to that item 22. Item 2 days, item 22.
No, it is because we followed the decision in case of Mukunda Dehari.
But delay limit is delay period is 323 days in instant. Delay 323 days, that was in the present case 466 days.
No, here.
Right.
Here, that case was disposed of basing on the decision of Mukunda Dehuri.
Right.
So challenge to Mukunda Dehuri was that order has been that appeal has been dismissed.
Right.
That was the reason why delay was not condoned. In this case,
Mr. Counsel, this, you have relied on a decision in case of Surma Manjari Das. That has no application.
facts are different.
But not only that, it was against these. In fact, this seventh order. That was not application. But please.
That is similar to item 22.
Those matters are pending for the Honorable Apex Court regarding that counting of job contract period that you are.
Counting of
Job
contract
contract,
period,
entire
job
job
contract.
contract.
Tell us, pick that item 22 after disposal of the SL.
So we will take up these matters also after that.
Right.
This is appeal after approval of SLPC number 94, which involves similar questions of all law and facts both
Okay.
as involved in the present appeal. So, yeah, it's-
Manchire ବୁଝିଥିଲେ କାଇଁ କାମ କରିନି ନା this is the
Yes.
27,
Item 27 also similar to that 22. Item 27 and 28.
Which?
Both. These are job contract.
26, 27, 28.
My lord. But there is a noting that your lordship may see in item 27 notice was issued.
All right, any case.
After undelivered.
Yes.
So you have to take notice again.
That I am saying that I have to take fresh notice.
Dispensing dispose of IS 369 of 2024 as notice issued to the respondent has in the matter of limitation has returned unserved with the noting undelivered report with insufficient address, comma, Mr. M.K. Khuntia, learned additional government advocate, raised for 2 weeks time to take steps for issue of fresh notice on the respondent opposite party number 1. List the case, if requisites are filed as within 2 weeks as undertaken, notice shall be issued fixing a returnable date within 6 weeks. List the case, 6 weeks. 8 weeks for a list.
6 weeks.
8 weeks. Hmm?
$29,
There is a delay millets. I filed an IA millets, IA number 514 of 24 millets. But there is a delay of 4 days.
State is the opposite party or there's some private party?
State. There is no private of it.
IA 514 of 2024. Just let me check. This is item
29.
Yes. IA 514 of 2024. This IA has been filed for condoning the delay of 4 days in filing the writ appeal. Considering the period of delay, we are inclined to condone the delay. We inclined to condone the delay in filing the writ appeal. The IA is accordingly allowed and disposed of. Writ appeal. List for fresh admission on 23/7/2024.
30,
Have you served a copy of the appeal memo?
Yes, madam. Get
copy of the appeal memo, if not already served, shall be served on the counsel for the state in the meanwhile. Yes.
30,
They've already served the copy.
Then last line ta kati din.
May I please?
Before my lord's submission, one submission in lordship, I have already filed the objection along with memo of citation, but unfortunately that has not come, but I have prepared two copies of this. Personal direct I can pass.
So what is the delay?
Delay in 418 days.
And what is the point?
Point is, on the
My
delay, the ground is.
I am for the appellate. The very small point in this case, the Honorable Court has disposed of the writ petition covering the matter along with another matter. That matter is different from the facts and circumstances of the case. Very small point is involved. Your Lordship, I have annexed that the order of the which has been relied upon and which has been disposed of. Your Lordship may turn to page 19. This is 30.
30.
What is the page 19? Yes. Lordship may say that this matter was
You
disposed
are
of
challenging which order?
page 19, my lord.
Challenging page 19.
My lord. This was disposed of in terms of the order passed in Premsagar Naik versus State of Odisha.
But you're saying it's not covered by that case?
I'll draw my lord's notes only two sentences, my lord. Your Lordship, I have annexed that Premsagar case, my lord, at its page 21. Lordship got it page 21, that Premsagar Naik case.
Yes.
Lordship may say the second sentence is at third line.
Yes.
The petitioner's father was a regular employee of the college and was discharging his duty since 4/11/1994. Here, my lord, his father was a regular employee. Then I will draw my lord's notice to the original, to the writ petition filed by the respondent. Lordship may see his pleadings. Page 33, my lord. Let's go to page 33. Para 6.2.
Page 33.
My lord. Para 6.2.
Three sons to.
Let's got it. That what I want to submit, my lord. The deceased father, namely Godadhar Barik, was working under the domain of the respondent as a temporary
Para
college.
3 of what? Page 33 of what?
My writ appeal, my lord.
Oh, there are two
writ
6.2
appeal.
paragraphs. That's the problem. Two paragraphs, 6.1.
Yes, that I am
The
saying
first one.
6.2.
6.2, first paragraph 6.2.
Yes, that I am pointing.
You are referring to page?
Page 33, my lord.
Of the writ appeal?
My lord, my lord.
Part of that. This is part of the OA.
Yes.
Lordship, the deceased father, namely Godadhar Barik, was working under the domain of the respondent as a temporary khalasi. He is not a regular employee. Then I will draw my lord's notice to the Rehabilitation Assistance Scheme, my rules.
Yes.
My rule 3 of the Rehabilitation Assistance rule says the assistance shall be applicable to a member of the family of the government servant who dies while in service. He is a temporary employee, he is not a government servant. And
that Prem Sagar, I have shown my lords that Prem Sagar Naik case that relates to a regular employee, not to a temporary employee. It is not covered by that Prem Sagar Naik case. And the Honorable Single Judge has directed dispute of the writ petition in terms of that Prem Sagar Naik case. This is the short point only.
Yeah, merit limitation. So we are ready to hear this application, this appeal, both on limitation and merits. So today you are ready? This is his submission, and his simple submission is that your case is not covered by that Prem Sagar Naik. What is that?
Let it come some other date.
Prem Sagar Naik.
Let it come some other date. There is a notification that the temporary employees are covered under the Rehabilitation Act
Maybe.
1990. But this was not taken in the counter affidavit. First time they are raising this
No,
ground.
that is not the question.
I'll
Mr. Counsel, that is not the question. The question is that your writ application was decided on the basis of law laid down in case of Prem Sagar Naik. The stand which they are taking is that Prem Sagar Naik is not applicable in your case. Simple thing. You may be entitled to relief which you are seeking, but you may not be entitled to that relief on the basis of Prem Sagar Naik's decision. So that is the only thing.
Yes, yes, Lordship, fix it. I will satisfy.
Fixed date, fix, we are here. We'll hear you tomorrow.
Yes. Yes.
Because such matters are required to be decided as
Tomorrow, Lordship.
Tomorrow, as requested on behalf of the respondent. And counsel appearing on behalf of the respondent has consented to final hearing of the present appeal along with the limitation petition on tomorrow.
Lordship, on Friday, I have filed the objection along with the citation that may be brought on record. That has not come.
The counsel for the appellant has brought on record certain citation in support of certain citations so as to oppose the application seeking condonation of it.
When-
Mr. Counsel, see something which is patently illegal cannot become illegal because of the lapse of time. So even if you are saying that condonation of delay, 5,000 days of delay can be condoned. If
Yes.
the order which has been passed is not capable of being carried out in terms of what has been held.
Lordship, I will satisfy this judge.
That period is immaterial.
Satisfy, Lordship, this judgment is covered in my case.
If you satisfy that,
Yes,
then
yes.
it's all right.
When did you file your objection?
Friday, Lordship.
Friday. No, Sita objection is giving copies. Section rest.
That's why.
Scan him.
31.
There's a delay of 47 days. The petitioner was appointed on NMR basis.
On limitation, I don't have an
We are
objection,
gonna-
47 days. It's a pension case, short date may be hearing for, and appeal memo be served.
Sir,
Appeal memo may be served on me.
All right.
All right. IA for 498 of 2024 dispensing with filing of certified copy allowed. IA 499 of 2024. This IA has been filed for condonation of delay of how many?
47 days.
49 days. Stamp report has shown 49.
49.
49 days and filing the writ appeal. Considering the period of delay and the reasons stated in the application, we are satisfied that it is a fit case for condoning the delay and filing the writ appeal. The IA is accordingly allowed and disposed of. Agute line likhe diyantu. Mr. Siddheshwar Malik, learned counsel, appearing on behalf of the respondent on account of the period of delay does not have any serious objection if the delay is condoned. Acha, writ appeal, copy has not been
No.
served. Have you served it now?
I'll serve it by tomorrow.
Tomorrow.
By tomorrow.
List the case on 20, next week? List the case on 23/7/2024 for fresh admission. Seta writ appeal le likhe debe. Copy of the appeal memo be served on Mr. Malik, learned counsel for the respondent by tomorrow.
32.
In 32, my learned friend has appeared and filed an objection. Also, similar matters are fixed to last week of July. That headmaster scale 32, 33, 34, and 35. He has filed an objection today. I'll go through it. You'll also fix.
So though in those cases also, it is on
Yes,
point
ma'am.
of
Last
limitation.
same question of point of law that headmaster
In that you filed your objection?
today.
Yes, to file you
The ones which are posted to that date.
one in that case also file. Today also.
All right.
Today to
So what is the date?
last week of July.
Do you have a number? You check for the, do you have a number of any of the cases?
I'll
Give
find
the
out.
number
I'll find
subsequently, all right. Mr. Sushant Kumar Mishra, learned counsel appearing on behalf of the respondent, files the objection to the IA for condonation of delay. You filing it here or filed it on registry?
File my on first day.
You filed it?
Yes, I will already
Submits that
filed
he has
first day.
filed the objection to the condonation of delay, to the IA for condonation of delay on 11/7/2024, full stop. It is stated at the bar that similar matters are posted to
Last week of July.
last week, date ta kayo na?
I am giving.
Are posted to last week, bracket, he'll give the date. Hence list this case on so and so along with the connected cases.
All four are same.
33, 34, same order.
35.
35.
32 to 35.
Yes, ma'am.
36.
Hey, please. In this case, 29 delay is there.
Delay is
29 days.
Me condone your lordship. Copy of the appeal memo is of the phone. I'm just
Copy of the
copying it.
appeal memo. Same order as in Mr. Malik's case. Same order as in item 31. Hala?
Your lordship, copy is already served.
All right. Copy of the appeal memo is served in court. Your name, please.
S. Shekhar.
S. Shekhar.
And in this case, I have also filed one IA for stay of the.
Fresh admission will be listed next week. You press it on that day.
A short date may be fixed.
Next week, 23rd.
Grateful, ma'am.
37.
37 means 145 days delay. Notice has not gone.
There's a delay. This IA has been filed for condoning the delay of how many days?
145 days, ma'am.
145 days in filing the writ appeal. Issue notice to the respondent. One respondent.
Yes, ma'am.
Issue notice to the sole respondent / opposite party on the question of condonation of delay. Returnable within 6 weeks. Requisite shall be filed within 1 week as undertaken. List the case after 8 weeks. 8 weeks data there. List the case on so and so.
38.
Yes, my lord. Particularly remember regarding promotion to Odisha Taxation and Service and the
38.
my lord. And the respondent is completing my lord 5 years, which they are saying that he has not completed. That
it was partly dictated, no?
yes,
The order.
Yes.
Your lords-
Draft
yes,
in the
your
file.
lords, the dictator the last is some
Yes,
there's
yes,
some
it was there.
Factual thing.
File on the draft order. Thivo.
Do you have the list of dates? Joined and
I have given that my lord, date set. I have given that date set.
If it is not there, call up Madam and ask her
Well,
to give it.
I have given that date set.
I'd asked her to
No, wait.
leave it in the
That is-
file.
that is- Oh,
What's there? Give it. Give it. Thank you.
Just give us the list of dates. When was he appointed?
I am giving that list. I have given that. Appointment is 23/8/2010.
He was appointed as
Appointed as Inspector of Commercial Tax.
Inspector of Commercial Tax.
Well,
Then on 23/8/2010, then what happened?
that I'll only you'll also see that date set. The deficit was convened on 4/12/2013. At that point of time, he was not considered for promotion.
He was not considered for promotion from the post of Inspector Commercial Tax to
Odisha Taxation and Account Service.
Odisha Taxation and Account Service rules. Then
In accordance with that rule, my lord, I have given.
rules you have given.
Yes, my lord, I have also given.
So this is OSFS cadre, Inspector of Commercial Tax.
Well,
Is this OSFS?
my first Odisha Taxation and Account Service, then next promotion is Odisha Finance Service. That is another rule is there.
No. What we want to understand, what is this Inspector of Commercial Tax?
Finance Department, they are appointed as Inspector of Commercial.
Just see your from your date chart, 4/12/2010.
Well,
First meeting for promotion of OSFS.
that is OSFS cadre, my lord. Odisha State Financial Service cadre.
So therefore, this Inspector of Commercial Tax is also OSFS cadre.
That is the feeder cadre. Feeder cadre, OSFS cadre, my lord. This is a finance service cadre. This is finance.
Where is that? So that is also covered by this. No. This is only Odisha Taxation and Account Service rule.
Yes, my lord. The commercial tax inspector is eligible for promotion to Odisha Taxation and Account Service. That is OSF's cadre, my lord. For a moment, you see Rule 6.
All right. Rule 6.
Yes. Right, Assistant Commercial Tax Officer, that is OSFS cadre.
Yes. Before, my lord, you'll also make Rule 4. First, you'll also see Rule 4.
Yes.
Here also Rule 4B. First Rule 4A that shall be filled up by directed to 50%. Then Rule 4B, not more than 30% shall be filled up by way of promotion from among the members of Odisha subordinate.
This is what I am asking.
Oh, sorry, my lord. Sorry.
This is not OSFS cadre. This is
Odisha subordinate.
Subordinate Finance Service.
Sorry, my lord.
So he was in Odisha Subordinate Service.
Yes,
Service cadre.
Odisha sub. Yes. Sorry, my lord.
Yes.
That is 4B. Then my lord, eligibility criteria is Rule 6.
Rule
6, my lord. Eligibility criteria for promotion.
Yes.
No member under Clause B of Rule 4 shall ordinarily be eligible for promotion to the service unless he has worked for at least 5 years in his original service or grade. That is the rule. So, what has happened? LRC has seen his date of appointment. Though his date of appointment was 23/8/2010, he got the appointment by virtue of my lord's direction in another writ petition against the recruitment year of 2004. As he has not completed 5 years, so he is not eligible for promotion to the OTAS. Sorry, my Odisha Taxation and Account Service as per Rule 6B. So, on last occasion, Honorable Single Judge had directed to consider his case. Admitted fact, his juniors have been promoted because they were appointed in the year 2004 by their own merit and by their own selection. He approved my lords, only got the order in 2010 and got appointment in the year 2000.
But when was the criminal case instituted?
Yes, ma'am. That I have given that date. She was acquitted in vigilance.
So
case.
when was that instituted?
That ma'am. In 2015, that sorry.
15, okay. because the
2015.
TR number is.
Sorry, madam, I'm
No, must have been before 13.
Right.
in the year 2015, my lord. 2015.
No, the PS case, vigilance PS case must be
Vigilance
there.
PS case, my lord, dated 26/5/2015. 28.
26/5/2015.
My lord. That is vigilance PS case number 28 of 2015.
All right.
No, vigilance case was in the year 2015, the 2013 DPC, why was he not considered?
Because he had not.
5 years. Okay, okay, yes, of
But
course.
your sale not completed.
Yes, got it. By the time second DPC came here, that criminal case had.
Yes.
Actually, this is.
Sorry.
That is why you kept it. This was little confusing. That is why I was also asking 2015 then. Okay.
Year number 1962 of 2024. The present order is being passed with the consent of the parties. Mr. M.K. Kotia, learned additional government advocate, and Mr. Vibhuti Bhushan Swain, learned counsel representing the respondent. Stop. This next paragraph. This IA has been filed for condonation of delay of 900 days without excluding the period in terms of the Supreme Court's order dated 10/1/2022 passed in miscellaneous application. So in view of the nature of the dispute, the present case, and considering rival submissions advanced at the bar, we deem it proper to exercise our discretion by condoning the delay and address the issue involved on merits. Stop. Next, this application is accordingly allowed. Stop. The delay is condoned. Stop. WA number 724 of 2024. The facts are not in dispute. Pursuant to a selection process held in 2004 for appointment of Inspector of Commercial Taxes in the state, under the state government of Odisha, the in the selection process covered, the petitioner had participated. Stop. He against his non-selection, he had to approach this court.
Normally, he has approached earlier to the state administrative tribunal.
Approach the state administrative.
That was dismissed. Thereafter, he approached this
administrative tribunal and then to this court by filing a writ petition giving rise to WPC number 13017 of 2004, which came to be decided on 19/11/2024. 2008 with following 2008. Stop. A review petition was filed by, who had filed the review petition?
State has filed the
By the state government against the order of seeking review of this court's order, which was dismissed by giving rise to RVWPT number 171 of 2009, which was disposed of by an order dated 19/2/2010. Stop. On the strength of the order passed by this court, the respondent was appointed as Inspector of Commercial Taxes, which is commercial taxes in Odisha Subordinate Finance Service Cadre on 23/8/2010. Stop.
May was appointed on 16/8/2010, but joined on 23/8.
Appointed on
8.
16/8/2010.
But joined on 23/8.
Stop. He had submitted his joining on 23/8/2010.
Well.
Stop. Where is the order of the High Court?
Your Lordship can find it, the affidavit filed by my friend on 1st July 2024. Your Lordship can get it from page. Your Lordship, affidavit filed by respondent on 1st July 2024. Your Lordship can get it from page
Like
9.
if-
Page 9.
Like it.
That order,
Like he is there. Like if yes.
the first order,
Like if I am spending time to find the High Court's order.
First order
Which?
is first one,
Page 9.
R/1. That is the first order.
What's up? It is. The other persons selected based on the set selection process had already joined in 2004. Yeah, is this correct?
Hello.
They had joined in 2004. Stop. Rule Odisha Taxation and Accounts Service Rules 2011 governs the rule to regulate methods for recruitment and conditions of service of persons appointed to Odisha Taxation and Accounts Service. Rule 4, B of which stipulates that not more than 30% of the posts shall be filled up by way of promotion from amongst the members of Odisha Subordinate Finance Service Cadre and such other categories of the employees as may be notified by the government from time to time. First off, Rule 7 of the said rules lays down the eligibility criteria for selection and
Let's me rule
Rule
6.
Rule 6, correct. Rule 6, eligibility criteria for selection and provides that no member under clause B of Rule 4 shall ordinarily be eligible for promotion to the service unless he/she has worked for at least 5 years in his/her original service or grade, and he has passed the prescribed departmental examination, if any. Stop. In 2000, on 4/12/2000, next, on 4/12/2013, the Departmental Promotion Committee meeting was held for promotion of the officers belonging to Odisha Subordinate Finance Service Cadre to OT and AS cadre for the year 2013. Full stop. The case of the respondent was not considered because he had not completed the residency period of 5 years as stipulated under Rule 6 of the so and so rules. Rules of 2011. First off, however, persons junior in the merit list, in the seniority list,
Gradation list.
in the gradation list, were granted promotion because they were appointed much before in the year 2004 itself. First off, it is self, which fact is not in dispute. First off. Next. This was also for the same cadre, 23/11/2017, for the same post.
Same post.
Next. It further transpires that a criminal case was registered against the respondents on
26/5/2015.
On 26/5/2015, and a departmental proceeding was also initiated against him in the year 2015. So stop. Next, in the other DPC held for promotion to the cadre to OT and AS cadre for the year 2016 on 23/11/2017, comma, the petitioner's case or respondent's case was not considered because of pendency of the criminal case and the departmental proceeding.
May was considered and kept in seal cover.
Was considered and was kept in seal cover. So stop. The eligible officers seal cover. So stop. The respondent was acquitted in the criminal case on 24/3/2023. So stop. The departmental proceeding which was initiated against the respondent resulted into imposition of punishment of censure by an order dated 7/12/2023. So stop. The respondent has been given promotion to OT and AS cadre with effect from 1/1/2018 after his acquittal
No,
in the criminal case.
no. He was acquitted, my lord.
After his
After his acquittal.
Maybe. The respondent has been given promotion to OT and AS cadre with effect from 1/1/2018 after his acquittal in the criminal case, comma, by a notification issued on 31/1/2024. So stop. Next, with a grievance that merely because of the pendency of the criminal case and departmental proceeding, his case for promotion to OT and AS cadre was not considered, and therefore he was entitled to promotion to OT and AS cadre with effect from the date from which the officers junior to him were promoted, comma, he filed a writ petition giving rise to WPC number 27269 of 2021, which has been allowed by an order passed by the single judge dated, what is the date?
16/9/2021.
16/9/2021. So stop. By the said order, the single judge has no. Single judge Hill as under. Go page 13. For the settled position of laws. वहां से टाइप करोगे फैक्ट इन्वॉल्विंग द केस, बीच में फॉर द सेटल्ड पोजीशन ऑफ लॉ. the said order passed by the learned single judge is under challenge in the present appeal. Full stop. Next. Mr. Kutia learned counsel appearing on behalf of the appellant has submitted that the respondent was rightly denied promotion with effect from with his juniors, in the light of clear statutory provision under Rule 6 of the rules of 2011, since on the date when his case was being considered by the Departmental Promotion Committee, he had not completed 5 years of service. So stop. He has argued that as criminal case and departmental proceeding were pending against the respondent, his case was not considered for promotion in the meeting of the DPC held on 23/11/2017. Stop. He argues that consequent upon his acquittal in the criminal case and conclusion of the departmental proceeding, the respondent's case was considered and he was given promotion to OT and AS cadre with effect from 1/1/2018. First off, he has also been allowed notional promotion at par with his juniors. Why was this withdrawn? Order 22/4. Why was this withdrawn?
My 24/2004 was withdrawn. That's the reason. He was granted notional. I have given that affidavit why you have withdrawn, because it has not taken care of the 2010 notification, so it was withdrawn.
2010 notification.
That appointment was not taken into account. He was allowed notional benefit, but subsequently it has been withdrawn. One reason as
Stop. Next. After having perused the materials on record and the submissions advanced at the bar, we notice that the petitioner could not be blamed for his delayed appointment in the year 2010. So, appointment in August 2010, when other successful aspirants based on the same selection process had already been appointed in 2004. No, stop.
In 2005, my Your Lordship.
2005.
Ma'am.
2004 लिखो पहले भी. Stop. It is true that denial by the first departmental promotion committee, first DPC, to consider the petitioner's case, respondent's case on 4/12/2013, when he had not completed the requisite period of 5 years in service, cannot be said to be unjustified. So stop. It was because of his delayed appointment. However, it was because of delayed appointment and appointment of the persons below in the merit list much prior to his appointment, that persons below in the gradation list were considered for promotion to OT and AS cadre in 2014. So stop. The persons below in the gradation list compared to the respondent's position were granted promotion to OT and AS cadre for the year 2013, comma, is thus an admitted position. So stop. Next. In the facts and circumstances of the case, comma, we are of the view, in the peculiar facts and circumstances of the case, we are of the view that there was no impediment in considering the respondent's case for promotion to OT and AS cadre for the year 2015. So no meeting was held.
No DPC has been held.
So stop.
Next DPC was 2017.
In the stop. Before the next DPC could be held, comma, a criminal case came to be instituted against the respondent. What happened in the seal cover? Seal cover.
That seal cover was opened and he was given promotion with effect from 1/1/2018. 2017, case was kept in seal cover. After his acquittal, he was given promotion with effect from 1/1/2018.
DPC. Since the criminal case and the departmental proceeding, since the respondent was acquitted in the criminal case and in the departmental proceeding, punishment of censure was imposed, comma, the seal cover was opened, and accordingly, he has been allowed promotion with effect from 1/1/2018. So stop. Next, in peculiar facts and circumstances of the case, as noted above, since the persons junior to the respondent have been granted promotion with effect from 4/12/2013, comma,
7/2/2014.
7/2/2014, comma, we direct that let the petitioner's case, respondent's case be considered by a specially constituted DPC for his promotion to OT and AS cadre for the year 2015, you cannot be given.
My lord, I completed my 5 years.
Because you joined on 23/10/2010.
10, my lord.
23/8/2010.
Yes.
So 5 years you must have completed on which date?
22/8/2015.
What is this time or the date must have been given for the DPC?
2017 DPC, what was the date?
For the 2017 DPC, what was the date? What should have been the date?
DPC date, my lord,
For the year 2016.
for the year 2016. 2017 DPC was for the year 2016.
No, therefore, for 2015 DPC, for 2000.
DPC held on 23/11/2017.
3 DPC was held for 2016. Accordingly, for 2015, when was the DPC required to be held or could have been held?
But that is not mentioned in that rule.
For the years for the years 2015 and 16. First off, if he is found eligible for promotion to the rank of OT and AS cadre for the year 2000 cadre in the meeting held for the year 2015 or 16, let him be granted such promotion accordingly. Stop. The impugned order passed by the learned single judge
May I submit, my lord?
is modified.
The order impugned is twofold, my lord. First promotion is from OT and Inspector Commercial Taxes to OT and AS, and the second promotion, my lord, to OFS Junior 1. Your lordship can see the order at page 13.
No, but what do you want?
My lord, subsequent promotion by
Subsequent promotion you will get because you have already been given from 1/1/2018. See, your other officers have been granted promotion with effect from 1/1/18.
Though they were working since 2010.
Your lordship, if I will get my promotion in the year 2014, when my junior,
the rules prescribe that the posts up to this shall be considered in that DPC. You are not clear on that. Therefore, given this, we have given this date 2015 or 16.
Yes. And my lord, if at all, my lord, they will consider for 2015 and 16, then subsequent promotion, my lord, which is held, my lord, 2021 to OFS Junior 1, then I will also, because the order impugned in the, my lord, by honorable
But you have
single
been
judge.
given promotion to OFS.
No, I have not.
Junior branch.
I have not been given because I have only.
It is further clarified that the petitioner's case for promotion to Odisha Finance Service 1 Junior branch shall be considered accordingly.
Yes. When my juniors got promotion.
Hmm?
When my juniors got promotion. my lord. Juniors in the gradation list, they got promotion.
That
Okay.
again, that again, there must be the this many years.
What is the eligibility criteria?
5 years. That is the residence period, 5 years.
That also is 5 years.
That is also 5 years. And also if I will get promotion in the 2016, then I will also.
For promotion, keeping in mind the date with effect from which the petitioner, respondent juniors have been granted such promotion.
Is otherwise eligible. 5 years. Okay.
21.
Your lordship's leave.
mention a matter which is item 45 on my lordship's weekly list. I was requesting, my lords, if it could be listed on the next Thursday or any day, which is convenient to my lord.
Wait for some.
Okay.
Item 21.
May I please, your lordship? The appellants has been convicted, both appellants, teacher 2 and sentence undergo life. In this case, my lord, the prosecution case that while the
No, it has come for what?
that hearing,
For here, final hearing.
yes, it will be very soft time. While the Promila house, the deceased, was returning from her land and reached in front of the appellant house. She detained and they detained her and the entire family consisting husband, wife and 2 minor sons as assaulted by means of iron pipe and lathis. On the next day of the occurrence, the affair was lost. In this case, my lord, on perusal of the entire evidence, it is a fact that there is no intention, no motive is there.
Right.
Lordship, kindly see in this case there are 3 eyewitnesses to the occurrence, and the prosecutor has given more emphasis on PW 3, who is a star witness, is eyewitness. Kindly see, my lord, page. Page
So
91.
paper book is there. It has not been scanned. Can.
I'm supplying to my lord translation copy of the affair. Translation copy of the.
This definitely he has given, but on the paper book, you can get a payslip number.
Then translation copy the Odia translation.
There are altogether 19 witnesses.
Yes.
So who have been declared hostile?
The 9.
18 witnesses.
Yes, there are 18 witnesses. And 9 and 15.
Have you prepared a note or no?
Yes, I have prepared. I'm one part, my lord. I'm denying that the assault party is concerned. I'm denying
Note that.
that assault party is concerned. That PW 3.
What is that?
No, I was asking a written notice.
No, he's saying something that I'm denying.
Denying assault.
Yes, assault as per the eyewitness person is concerned.
No, eyewitnesses have stated that you have assault.
Yes, that
assaulted.
part I am denying.
Denying or challenging?
This is that challenge.
So you cannot accept that.
Yes, the page 90.
9. Yes.
Page 91.
9.
91. Who is a star witness of the case? She is the mother of the deceased.
No, 18 witnesses.
Yes.
Out of them, who
The
are
three
the,
is the eyewitnesses.
as per the prosecution,
Yes.
3 eyewitnesses.
Eyewitness. That 1, 2, 3.
Who? PW 1, 2, and 3. Okay. So they are the relations.
Yes, the 2 and 1 I am denying it is not evidence because only
No, you are denying, but those 3 have supported.
Yes. 3 is the main witness, my lord. Kindly see.
And who is 4?
4 is the seizure witness. 4 and 5.
6.
6 is also, my lord, it is seizure witness. It's wearing.
Better if a detailed note is given who is what not, then shall convey. Otherwise, only because my friend is saying that he will distinguish the evidence of PW3, who is the relation, and there is not some aberration in the evidence cross-examination notes. but there are also two witnesses. So better if my friend can prepare a note evidence wise so that it is convenient for the lots.
Let us understand. Seven.
Seven is the post occurrence witness. Post occurrence witness. 8 also post occurrence witness. 9 also post occurrence witness.
Yes.
Who became hostile? The informant.
Who?
P2 9.
Yes.
10.
He is the informant.
Yes. 10 is also hostile. Ten and 14 are hostile. 14.
Yes.
Post occurrence witness. 11, 12 post occurrence witness.
What is the post occurrence witness?
That after they have the hearsay.
Hearsay, or they reached the spot after the assault was
Yes.
over, they found the deceased lying there.
And 16 is the doctor.
13.
16. 13 is the post occurrence witness. A witness to the seizure of wearing apparels. 14 hostile.
11, 12.
That post occurrence.
Oh, one by one.
13.
13 the seizure witness to the wearing of apparels. 14 the hostile.
Slowly. PW 13, he says, is witness to seizure of wearing apparel.
Yes. 14 hostile.
Wearing apparel of deceased or appellant?
That accused persons. (14) 15 is a seizure witness.
And 14?
Seizure witness to the open
14.
14 the hostile.
Are
That is his after hears evidence, but he is hostile. He became hostile. 15.
Who became hostile?
14. And 15 seizure to the weapon the offense.
hostile witness are PW 9 and 14.
Yes. 9, 10, 14 are hostile. 16 is the doctor. (17) is the scriber of the affair. 18 is the IO. Kindly come to page 91, the PW3. PW3 with the eyewitness to the occurrence, page 91.
No, why not PW1?
PW1, my lord, PW1 is only examination chief.
Why not
Subsequently, my lord, that prosecution initially was declined. The prosecution initially was declined. Subsequently, filed 311 petition for recall.
So you declined?
Yes. Yes.
How can you be given benefit of that?
Because he has filed 311 petition. 311 petition for recall of that witness.
Why? This is not the way.
No, that thereafter he has challenged before the High Court.
Yes.
This honorable court.
Yes.
The honorable court directed to fix a date and to give the evidence on such and so. At that time, he has expired.
No, that will not. That will go against you.
That can be evidence. But evidence means examine chief and cross-check.
We understand that.
Yes.
We understand.
Because that is the direction. And number 2 is the eyewitness. I am disbelieving this.
So when did you apply for, when did you make your application for recall?
That
of the witness?
2018. I'll provide that
I've already stated to royal court advocate to produce the
No,
circular.
not required. That is not material.
That is on the record, so I think it's the LCR is
Yes,
there.
yes.
And also, my lord, you will kindly say period 3.
I guess.
Two appellants, I think one. How many appellants?
There are 2 appellants. He's in custody more than 9 years. My lord, page 91. I know the accusation, the deceased is my daughter. I know the informant the last year in the month of Asada, the occurrence took place at 6:30 p.m. near the house of the accusation. At that time, I, along with my daughter and grandson, was returning from paddy field. On the way near the house of the accused person, the accused Madhu dealt a blow by iron pipe on the head of my daughter, who fell down. The Madhu Sahu, the appellant 1, Tilei, 2, Prem and Muni, both are minor, assaulted the Pramila, the deceased. Madhu assaulted the Pramila by an iron pipe. Tilei, Prem, Mani, and assaulted Pramila by lathis. When I tried to save my daughter, Tilei dragged me and pushed me away. Tilei, Prem, and Mani would a little, but Madhu was assaulting Pramila. Next, madam, kindly see the proceedings part. Para 4. On one side of village, Limdi, there was Lankan Pada, and on the other side, the village, there was Chahuk Pada. There is concrete road in village Limdi. The occurrence took place on the concrete road of the village. The house of the Vikram Maji.
Where are you reading? Prosecution of?
Para 4 of the prosecution.
Of?
Period 3. Page 92.
2 you are not to. First, you are starting with PW3 first.
Yeah, period. Then I will go to period 2. Para 4, you also got it. Para 4, page 92. The occurrence took place on the concrete road of the village. The house of Vikramaji, Bechanbaji, situated at a little distance from the house of the Madhu Sahu. The house of Ratan Malik, Gandhar Malik, and Fateh Malik, situated on the other side of concrete road. The 5 is the important minor. I am 65 years old at present. It is not a fact that due to old age, my eyesight has become poor. At the time of occurrence, evening had not set in. I had not seen outsider in the road at the time of occurrence. My house and my paddy field situated by the side of the village road. My daughter was strong and stout. First, it is important. First, Madhu held the hair top of Pramila, wheeled her, and fell on the ground. When Madhu tried to assault her by an iron pipe, Pramila held it, and immediately Tilei, Prem, and Mani assaulted the Pramila by lathis. This statement is important. But you will kindly see the page period 6, the doctor evidence.
Yes.
Period 16. The death due to my lord head injury and hemorrhage. Lordship, kindly see page 109. Second line. It is a fact that I have not mentioned in my report that injuries sustained by the victim were sufficient in ordinary course of nature to cause her death. I have also not mentioned in my report whether the injuries were antemortem or postmortem in nature. It is a fact that I have not mentioned the mode of the death of the deceased in my report. I have also not mentioned in my report the death was a homicidal one. That is, that if he has will the top on the surface, that it may be it is accidental case. It can't be murder case.
So what are you reading?
I am reading period 16.
Medical evidence?
Yes.
Medical evidence, there are eyewitnesses. And how can you say whether it is a homicidal or suicidal? How can the doctor say? The doctor cannot certify whether it's a case of homicidal or suicidal death, or even otherwise accidental. The doctor has only a duty to find out the nature of injury, the injury, that's all.
he has not given
And
a.
when there is direct, the witnesses are saying, eyewitnesses are there, why should we disbelieve them?
Because my lord, the as per the eyewitness has not give the iron pipe on the head of the ear, because in a cross evidence he has.
See, Mr. Counsel, only on the basis of examination of PW1, the conviction can be sustained. For the reason that she was no more during the course of the trial, she was examined, and you declined to cross-examine.
That can't be, my lord. I'll provide that decision, my lord.
No decision can be of that nature.
That is there, my lord. That appreciation.
No,
PW3 has denied the your suggestions that she has not stated that you have assaulted on the head with the iron pipe.
Yes,
So that portion you have left.
but
That cross-examination also you have done first declined and then called her. So then you have
Para 5,
supported.
yes, she has stated, narrated, my lord.
Paragraph 6.
Yes, paragraph 6.
You have not read that paragraph.
I was examined by the police on next day morning. FIR was lodged. It is not a fact that I have not stated IO. Delay dragged me and pushed me away. It is not a fact that I had not specifically before IO that Madhu dealt a blow by iron pipe on the head of my daughter, who fell down. It is not a fact that I have not stated to the court on earlier occasion Madhu dealt a blow by an iron pipe on the head of my daughter, who fell down. I do not know if there is a difference between the iron rod and iron pipe. When I examined by the police, I stated Chhattisgarhi language. It is not a fact that no such occurrence had taken place. Madhu, Tilay, Prem and Mani has not assaulted Pramila, and but it has been converted to the IO, PW 18. Lordship, kindly see. One 28.
Yes. 3 eyewitnesses.
128. Your Lordship, kindly see. I'll go to that second and last person. It is a fact that I have not seized the Malkhana register in the same. I have not filed any extract of the Malkhana register. It is not a fact that I have not kept any weapon of the offense of BS Malkhana. It is a fact that Odisha police manual in the statement of witness to be decoded, but in the language in which witnesses speaks. Further, it is a fact that PW3 has not stated before me that relay dragged her and pushed her away. It is a fact that PW3 has not stated before me that accused Madhu, the appellant one, dealt a blow by pipe on the head of the daughter. He has not given the head. There is no specific. That is omnibus.
how are you related to the deceased?
Deceased. He is a neighbor. Prosecution is trying to brought out, my lord, that there is law of affairs between the appellant one and the deceased. Because there are some landed properties she was in, for which her husband left. This is what it has not been proved. The motive part is not proved. So the intentional part is concerned, my lord. But as per the statement of the people who is a star witness to the occurrence, it is a death due to negligence.
So how the intention can be proved?
But there is no, because the death is due to negligence, because first he has he has
Negligence.
Negligence. Yes, sir. That is the negligence. Part 5 of the cross examination. Appeal 3. Para 4 is a concrete road. Para 4 is a concrete road. Para 5. First, Madhu held her hair top on Pramila, the deceased, wheeled her, and left her on the ground. When Madhu tried to assault her by an iron pipe, Pramila held it immediately. That is the surface is the hard. Surface is
So negligence, who? Pramila was
Yes,
negligent,
so-
falling on the floor.
yes, they are on the
Pramila should
road.
have been careful.
Well,
She should have been careful.
She should not have fallen on the road. What are you saying?
that is the hard surface.
So she should not
might
have fallen.
The head must be
No question of negligence, where does it come?
by the part. That death is due to negligence. Negligence part is why not that
That the person who caused the assault should have been careful enough that the head of the deceased does not hit the hard surface of the road. This is what you are saying.
that he don't surface. The wheel and he fell down on the surface. That is a concrete road.
Whose negligence?
The nature of injury does not say that it is by the iron or stick, because they have recovered the iron pipe and stick with blood. As for the report says, as with chemical, there is no blood was there. That is stated. That is my lord page 130. There is no blood stains there. And the injuries, that the nature of injury is not does not say whether it is inflicted with iron pipe or stick. Has never said, and it is also never said it is a homicidal or, and also is a.
Why are you repeating this homicidal or?
By some it might be accidental.
Might. Every accident can be accidental. Every death can be accidental.
Yet a statement whether the injuries are antemortem or postmortem in nature. He has not given the any here. In fact, I have not mentioned the mode of the death of the deceased in my report. Because of the either the death of accidental.
Opinion regarding cause of death is head injury leading to compression of brain matter and hemorrhage.
Yes.
So that is suicidal.
No, I have not. It is accidental. My submission is accidental. Because as a statement of P23, well, first he has given the iron blow, iron pipe blow, and he has held it.
Your submission is incorrect. The injuries sustained by the victim were antemortem in nature. So that doctor has stated.
Yeah, that's straight with the
Page 17. Paragraph 1, after the injuries.
Page, sir,
And the injuries sustained by the victim were sufficient in ordinary course of nature to cause death.
It has cross-examined that evidence. The corresponding the para 5. Para 5 is the cross-examination part. It is a fact that I have not mentioned in my report the injuries sustained by the victim were sufficient in ordinary course of nature to cause death. I have also not mentioned in my report whether the injuries were antemortem or postmortem nature. My submission of death due to the accident. It might be accidental.
Counsel, you'll have to make out a case that the eyewitnesses 1, 2, and 3 are not trustworthy. If you can't establish this, then you can't succeed. But the main question is,
yes,
why should we disbelieve the evidence of PW1, PW2, and PW3? Who are the eyewitnesses?
Yes.
Who are the witnesses of the occurrence of assault 1 and 2? See that this is an admitted fact. 3, there were injuries found on the body of the deceased. So these are proved facts. So unless you get over this, you cannot succeed.
I'll cite my lord.
What cite?
Sometime you'll also only
Time
2
is
days.
over.
Only 2 days you'll also.
Time is over.
Next.
Yes, who is for the state?
On the
I'm there for
next week.
Plus, if you also go through the evidence of PW 120, they are more consistent and they the defense has not come out with any contradiction in the evidence of all these three millards. And PW1, who is the eyewitness, he was declined. He was declined in the year 2016, and thereafter, in 2018, an application was filed to recall. So, we have section 136 of the Evidence Act. Because PW1's evidence is sufficient to convict them, even forget about 2 and 3 millards. And there are 14 injuries on the body. And the doctor has opined that all these injuries are antimotive in nature. And there are 7 internal injuries, not on dissection.
No, but had there been any intention to kill by the assaults made by the this thing?
That is the it is stated by the witnesses that the deceased had 7 acres of land in her name, and because she was deserted by her husband, the accused number 1 had a eye on those land, and he wanted to have relationship with her, and wanted to marry her, which she denied, and that is the intention. And for that, there was also a criminal case earlier. The appellant number 1 had tried to molest her earlier, and for that there was a criminal case pending against her.
Him.
So what advantage was he going to get by killing her?
But because he denied to accept the offer and give the land.
He might have assaulted her. He might have done something but how? By murdering? Why would he murder her?
That has not been specifically stated by any of the witnesses, but only question is because there was a unequal terms between the.
So whether it will come under 3 and 4 part 2, that is the question.
Maybe part 2 may not be there, 1 may be there.
One, all right, 1. Examine
that aspect, but considered 13, had there been a single blow, Your Lordship, I could have considered for part 2. Had there been a single blow on the body, I could have considered for part 2. But we are successful 14 blows on the body, milords. So maybe part 2 may not be that aspect I will examine, milords. I will come up.
Examine.
Yes.
So far, 2 is concerned, his evidence, his
and what is your period of custody?
He is already 9 years. More than 9 years.
9 years, 9 years is nothing.
More than 9 years. But 2 is not reliable because he has stated I am his neighbor. Because as per the
1 is 9 years.
More than 9 years. The wife is 7 years. He is on religion bail.
No, Peter, appellant number 2 has been granted bail by Your Lordships. So far 1 is concerned, his bail application was rejected.
The third counsel appearing on behalf of the appellants and learned AGA for the estate. Place this appeal for further hearing on 1 week to be taken up at 4 p.m. Yes.
$39, 47, Your Lordship, I have made a mention in the
Which item?
item 47.
Yes.
37, Your Lordship has issued notice. My learned friend has appeared.
39.
39.
39. 39.
39, my lord, I have this is a case of dismissal of the petition respondent. I have filed they have filed after 236 days delay. After judgment was passed by the honorable single judge by granting 2 months for reinstatement. Thereafter, my lord, after 4 months, the first contempt was filed.
All right, we have to consider the
First contempt, second contempt. Thereafter, my lord, after 8 months, when the personal appearance was there in the second contempt.
How much money do you want?
The money, my lord, he is out of employment since last 6 years. My lord. After waiting for 8 months, they have filed 9 months after.
20,000?
And your lordship, like.
Your lordship is exempting 100 days.
Yes, therefore,
So 137,000.
only 15,000.
Madam.
15,000.
Thirty-six days, 236. This IA has been filed for condoning the delay of 236 days in filing the writ appeal. We have heard Mr. M.K. Kuntia, learned additional government advocate, and Mr. K.C. Sahu, learned counsel, appearing on behalf of the respondent. We have gone through the IA. We have we have gone through the IA, paragraph 4 and 5 of the IA, explaining the reasons for the delay in filing the writ appeal. Although we are not completely satisfied with the reason cited for the delay in filing the appeal, but considering the but in view of the interest of justice and the nature of and the grounds taken in the writ appeal, we are satisfied that this is a fit case to condone the delay in filing the writ appeal, but subject to payment of some cost to the respondent. The IA is accordingly allowed the delay of 236 days in filing the writ appeal is condoned, subject to payment of cost of rupees 15,000 to the respondent within a period of
Lordship fixed 2 weeks.
within a period of 2 weeks. List the appeal. The IA is accordingly allowed and disposed of. List the writ appeal on 2 weeks तक ये complete हो जी 29th. List the case on next week. List the case on 5/8/2024 for fresh admission. A copy of the appeal memo may be served on Mr. K.C. Sahu, learned counsel for the respondent.
Obliged, madam.
Yes.
40. Already notice requisites filed. There is a noting that your lordship may say that noting
Non-filing of postal requisites.
already filed.
Mr. M.K. Kuntia, learned additional standing counsel, additional government advocate submits that postal requisites have already been filed. When had notice been issued?
The notice was issued on 9/5/2024.
9/5. Okay. When did you file?
11/7/2024.
Submits that postal requisites have already been filed on 11/7/2024. Considering the said submission, issue notice to the respondent on the question of limitation, fixing a returnable date within 6 weeks. List the case on after 6 weeks. Please give me a date.
27/8.
27/8 is completed after 6 weeks. Then the next week. How much? 2/9/2024.
Forty-one, 145 days date.
No, but what have you challenged?
Well,
What have you challenged?
31.
Yes.
Rehabilitation matter 118 days delay.
All right. IA 2422 of 2024. Please give me the number of days of delay again.
118.
118. This interim application has been filed for condemning the delay of 118 days in filing the writ appeal. Full stop. Issue notice to the respondent / opposite party on the question of limitation by registered post with registered post / speed post with AD, returnable within 6 weeks. Requisites for which shall be filed within 1 week. List the case on that one. What is that date? 2/9/2024.
42.
Same order.
42,
Only number of delays, how many?
124 days.
124.
24 days.
43.
43, Your Lordship. The appellant counsel, Ms. Sagarika Sahu, is currently out of station. Therefore, seek for an adjournment, Your Lordship.
IA for stay. So this is for fresh admission.
Lordship.
Just a minute. This name sounds familiar, probably. What have you challenged in this?
Lordship, the appellant counsel actually sees out of station.
So you don't know what the case is about?
Lordship, I'm on behalf of her.
See, the name sounds familiar. Who's there for the state? Oh, this is not a. Oh, this is not a service matter.
43.
No, the other side I'm asking higher education. All right. No, it's all right. Not this is okay. Okay. Next week. Prayer for adjournment is you are Miss
Sucheta Guman Singh. S. Guman Singh.
S. Guman Singh. Prayer Miss S. Guman Singh, Learned Counsel, prays for an adjournment on behalf of Miss Sagarika Sahu, Learned Counsel, stating that the case will be argued by Miss Sahu. List the case on 23/7/2024.
Obliged, Lordship.
44.
May I please, Your Lordship? My Lord, there are 97 days delay in filing the writ appeal.
What have you challenged?
My Lord, delay is only.
Delay is 90 days, but what have you
97
challenged?
days.
What have you challenged?
My Lord, I have challenged the annexure 8 manual.
What is that?
Impugned order. In this order,
Grant of compensation.
my Lord, grant of compensation under OERC regulation 2020. As per this, the petitioner appellant is the wife of the petitioner husband. Petitioner appellant was died due to electrocution.
One of the grounds for rejection is that appeal is maintainable. And that clause 11.
Mr. Counsel, your writ application was dismissed on the ground of availability of a remedy.
And you had earlier approached this court and the court had disposed of, stating that you may move the OERC.
My Lord. Annexure
Then why are you wasting time here?
My Lord, Annexure 8, impugned order. Kindly see page number 45, paragraph 5, my Lord. My writ application has been dismissed by Honorable Single Judge on the ground that there is also no material on record to show that Annexure 7 was in fact received by the Secretary, Energy Department. Already, Energy Department has confirmed that this Annexure 7 is received by the Energy Department.
No, but that is a different aspect. If you have alternative remedy, you should avail that.
My Lord, through Annexure 7, I have availed before the.
Now you are saying you've submitted this letter to the secretary or by registered post.
My lord.
So this is what is wrong in the order. We're unnecessarily wasting your time here.
My lord, already I have approached the Energy Department Secretary. Kindly see Annexure 9, page number
No,
51.
Mr. Counsel, it is mentioned that this court directed and counsel for the petitioner to proceed to produce proof of receipt of appeal by CEO so and so TPCO DL Bhubaneswar. Although the appeal has been filed, but the petitioner has lost the postal receipt.
My lord, already I have approached. At the time of a hearing of the writ application, I produced the receipt, postal receipt. But the Honorable Single Judge did not consider my postal receipt application.
So we should ask him to file counter affidavit.
My lord,
Should we ask
no, my lord.
my lord to file counter affidavit?
No, my lord.
That
No, my lord.
what kind of submission you are making?
Without considering that part, my writ application has been dismissed.
Pursue your remedy. Grievance is that you filed an appeal. You filed an appeal, but you could not prove that the appeal was filed. All right. According to you, the department acknowledges that you had filed the appeal. Therefore, your appeal must be pending. So therefore, the Honorable Single Judge observed that you should pursue your remedy before appropriate forum.
My lord, in the writ application, my prayer was that the appellate authority Energy Department did not consider my representation, for which I have approached this honorable court before single judge.
So representation, whether it was the representation or appeal?
My appeal. Appeal
Why are
in
you
form of
saying representation?
appeal in form of a representation I have made.
Appeal against which order?
My lord, there was no order, but it is the appeal was preferred against the non-redressal of my grievances as per OERC rule 11. My lord. My lord, kindly see page number 33, OERC regulation 11. Appeal. If the claimant or the person entitled is aggrieved with regard to entitlement of a compensation or quantum of a compensation in accordance with the regulation or non-redressal of his grievance, he may file appeal before Secretary, Department of Energy, Government of Odisha, whose decision in this regard shall be final.
So you have filed?
My lord.
So what is the proof?
He is not considering my appeal.
It is the proof.
My lord.
Page 42.
Page 51.
What is the later one?
The order is at annexure.
This is the order we have.
No,
9/1/2000.
9-1. First one was 25/7/2023. Pursuant to that, he has filed the appeal with the postal receipt, but that is all.
So this is what you prefer an appeal. Is there any time limit prescribed?
No, my lord.
Then you prefer an appeal.
My lord, I have preferred appeal for non-redressal of my grievances, but it is still pending. It is not considering my appeal.
Then
Kindly see Annexure 7. The appeal which he means, your lordship may kindly, it's in vernacular language. That is an appeal, it's a statutory appeal. He should have filed an appeal in proper format. He is only your lordship may kindly have a glance Annexure 7. Just as application. So let him file it in proper format.
Prefer an appeal.
So if that is, they are bound to consider it.
you have given us as a letter.
Like a letter.
Appeal has to be in proper format with proper prayer.
With a proper.
My lord, it is a village poor people, he is
So poor
not aware.
people, poor people will not follow the procedure of
My lord, he
poor
is-
people we can entertain when they come with a report.
Just a minute, he is a poor person.
My lord,
Is he a poor person?
poor and he is not aware about the format.
He is not aware about the format.
My-
Does he know what is the format of the writ proceeding? Does he know how writ petitions are filed in the High Court? Huh?
My lord, he
Whether he knows this or not, how a writ petition is filed in the High Court? Whether he, because he is a poor, whether he knows how writ petitions are filed in the High Court?
no, my lord.
He doesn't know,
Yeah,
but he has filed.
My lord, his law and advocate has filed the.
And
He has gone through his.
you also
So
file
land
appeal
advocate could
on
have
his behalf.
drafted
lord.
an appeal also.
My lord.
And if the land advocate cannot draft, we have this system in place.
My
We can ask the legal services authority.
my
If you can't do it, we will ask someone in the legal service authority. So you don't want to file. There is delay of
Take
how much?
help of Mr. Satpathy.
My lord, I may be permitted to file statutory appeal before the
But
concerned
also for the
authority.
petitioner, after some argument,
I may
seeks
be
permission
permitted.
to withdraw this writ appeal with a liberty.
In proper format, correct?
With a liberty to file an appeal in accordance with clause 11. What is that?
My lord, appeal.
Clause 11 of
Clause
the
11 of OERC rule.
OERC.
Clause 11 of
OERC regulation. 22
OERC
OERC what?
rules.
Odisha Electricity Regulatory Commission.
clause 11 of the regulations, yes. OERC regulations,
OERC
regulations.
bracketed compensation to victims and electrical accidents, bracket close, regulation 2022. This application is appeal stands disposed of with the liberty as sought.
My lord, time may be fixed for a.
File first.
My
45.
May it please attentions. Lots in this item, there's a delay which is pointed out by the registry. That's how it figures in orders. Though it's a fresh matter, the
So
order
what is the delay?
delay is for 24 days.
The notice will go.
What have you challenged?
I am classified as a fraud account without being even noticed. The single judge says there's a Supreme Court judgment that's also cited, SBI versus Rajesh Agarwal, that principles of natural justice are applicable to master circulars of willful default or even fraud. So, my lord, that specifically pleaded, and even that's their part of the written submissions, which is my last annexure in this. That was specifically pleaded that I need to be noticed and I need to be heard. So I've not been heard. I'm classified as a fraud account, my lord. So penal consequences.
Notice will go.
This interim application has been filed for condoning the delay of 24 days.
24. But my lords, can I just say there's actually no delay. The registry, because the order was uploaded only on the 30th of May. So I applied on the same date. The order is of 26/4, but the order was uploaded. If your lordships would see the annexure, it itself shows that the order was uploaded on 30th
You
of
should
May.
not have filed the application then.
I have filed because, my lords, the registry pointed out. So out of,
The registry, if the registry asks you to do.
my lord,
something,
sometimes to get the matter listed, we filed it, my lord. So that's how.
All right,
out of-
you'll see later.
So, I mean,
Actually, there is no delay, my lord.
No, no.
With respect, my lord.
but since you have filed, let us hear the opposite parties. 24
As it-
days, okay. Mr. Tripathi,
Panigrahi.
no, you don't hold power. You're Mr. Tripathi?
I am Ashok Panigrahi.
Panigrahi, sorry.
Sorry.
Oh, that is, I mean, Mr. Ashok Panigrahi. Mr. Ashok Panigrahi, learned counsel, appearing on behalf of Mr. Pratik Das, learned counsel for the petitioner, submits that although the registry has pointed out a delay of how many days?
24 days.
24 days. There is actually no delay in filing the writ appeal, as the order in question was uploaded in the website on
30th of May.
30th of
2024.
May 2020,
For
2024.
yes,
An application for certified copy has been
Was-
filed on
on the same day. That's 30th of May.
the same day, and the appeal has been filed on
Appeal has been filed on 26th of June, my lords.
26 June 2024. So when did you receive the copy?
My lords, we received the copy on the 5th, my lords.
5th of
5th of June.
how can it be? You applied on 26th.
No. The order is of 26/4.
Yes,
It got uploaded on 30th of May.
all right.
I applied on 30th of May and it was supplied to me ready delivery supply on.
The appeal has been filed on 5. No, you
I filed, my lords, what I'm saying.
filed it before.
I filed it on 26th of June.
Huh?
But what has happened is the registry has been calculating it because taking 26/4 as the date, whereas the order was only uploaded on 30th of May. That's why I said that no delay would be made out in this matter.
Issue notice to the opposite party, issue notice to the respondent opposite party on the question of limitation returnable within 4 weeks, requisites for which shall be filed by within 3 days. List the case 4 weeks for a date.
20.
My lords, can I request for a notice on the IA, the interim? Because now that I'm on delay, I can't even press my application.
We can issue notice. Yeah, so the likhe the writ appeal IA already. We should notice on the IA, I mean for IA for stay also. We notice issuing notice on the writ appeal as well as the condemnation of delay.
Lords,
Then
I was
after you can
making
move
good
that.
my case that actually the delay would, I would have otherwise pressed because without hearing me was penal consequence, because right now what has happened is, my lord.
The point which you are making is available to the person also against whom this appeal has been preferred. He has also a right to be heard. against the-
Certainly, I'm
on the
not saying
point of
without
limitation.
hearing me. I'm just requesting that if your lordships considers it fit, then up. On the interim relief, if your lordships could issue.
Interim relief, we cannot grant.
No, I'm not saying grant relief, my lords. I'm saying issue notice on the
All right,
application at
issue
least.
notice.
Because now that your lordships are not granting, please issue. So then the next date I can press. the
All right.
Date.
What is the date?
20th August.
All right. 20 August, 20 August.
Obliged.
46.
Your item is 47? Yes. 47.
7.
46 tomorrow.
47.
May I pray, my lord? On 27th July 2023, Railway issued a tender for a rail link project. 27th July 2023. I was evaluated to be a L1 bidder. Let's see if I have made a small date check for the numbers.
Yes.
My lord, on 3rd of June 2024, as the LOI was granted in my favor. Your lordship, I'm directly taking to that document that your lordship find out at page 1, 2, 3 of the writ application. Page 123, my lord, of the writ.
Yeah.
Lordship may skip 123, there is no dispute. At page 124, may I place, my lord, it's the letter of acceptance. You are requested to submit the proper man guarantee in form of as given in clause 7.1 of the article 7 of the standard EPC agreement equivalent to the 5% of the contract value amounting to rupees so and so within 30 days from date of issue of the letter of acceptance. Letter of acceptance, validity of the stipulated date of completions plus 60 days so that the
Sir,
contract.
The difficulty is that this action was taken on 3rd of June.
Yes, madam.
You approach this court
Yes, madam.
and you obtain an order that your representation should be disposed of. And today you are pressing for urgent hearing of the matter.
No, my lord, that a little bit, there are different, my lord. Lordship may kindly turn. On 3rd, when I received it, your lordship, that page 125, your lordship.
Why did you accept that order? We will also dispose of your application, file another representation.
My lord,
Let them file affidavit.
well, they have been directed to file affidavit on 1st of July.
All right.
They have not filed, my lord. And my predicament, why I'm pressing your lordship thrice, because in between they have issued a notice, and that is after the issuance of the notice by this honorable court. That is why, that is the pressing necessity for which I approached your lordship.
You had that pressing necessity in June also. The pressing necessity which is now was there in June also. But you got an order. You were very much satisfied with the order.
Immediately.
And now you want the court to take up your matter of profession
Immediately after that.
on merits.
Immediately after that, they rejected it on merit by giving an order. That's a speaking order has been given.
Let us see where is the order impugned.
My lord, that's at page 140. It starts from page 138. Before that, if your lordship allow me in 2 minutes, I will take the matter.
Yes.
My lord, on third, when I gave this letter of acceptance was given to me at page 124.
So you are at annexure 9 or what?
My lord, I am at annexure 2 at page 123.
Annexure 2.
Before I just pray your lordship, before I go to the impugned order, lordship may allow me just 1 minute to give you the sequential situations. Lordship may kindly that page 123 is the letter of acceptance. This letter of acceptance, for the first time, they asked me to deposit additional performance security. That's in dispute. Apart from performance security, Lordship may pays at 125. On the date of its acceptance, I resented such action, saying that additional performance security is not payable. At 125, your lordship, I have written it. Then, my lord, on 4th itself, I have given my representations saying that this additional performance security is not leviable under the impugned tender. And on 7th, I deposited the 5% performance security. Though period of 30 days was granted to me, on 3rd I received, and 7th I deposited the 5% security of 9 crore rupees. Now, over this 4th of June letter, they didn't sat silent. Then I read again on 12th. On 14th, they write me that the additional performance security is required to be paid. On 14th of June. On 17th, I just again put them to saying that different clauses of the contract in my elaboratively that this is not how it is not impossible under the tender conditions. And that stage I came before your lordship and the representation was disposed. Now your lordship see the impugned order. What is my main grievance, your lordship, is that the performance security under the NIT, there are 2 clauses, identical number is appearing. And I'm taking your lordship to that clauses first. Your lordship will kindly have that at page 63 and 64. Has your lordship got it? Now, page 63 is 2.21 performance security. Within 30 days of date of issue of LOI, the selected bidder shall furnish the authority an irrevocable unconditional bank guarantee in the said form draft for an amount equivalent to 5% of its bid price. I did so on 7th. This I have complied. For detailed provision of the performance security, refer to clause 7. I am at page 63, internal page 32. Now, my lord, the second clause appearing in the same nomenclature, 2.21, this performance security, again it is a performance security.
Yes.
And at another page. So the same clause appearing twice. Here there is a demand for additional performance security, but again it says for detailed provisions of performance security and additional performance security, refer to clause article 7 of the draft EPC. Now, my lord, draft EPC I have annexed that your lordship kindly find out. There is not a single word used called additional performance security. Page 112. It's own.
Additional performance security is there in 2.21 Roman 3.
Yes, my lord. That's the twice appearing clause. As I have shown your lordship at page 63 and 64.
Yes.
My lord. So now, in both the clauses, there is reference to Article 7 of the draft EPC.
No, articles are also same, 2.21, 2.21.
Yes, absolutely. Identical, nothing has been changed here. And I have complied with the space 63. That is not in dispute. Now, my lord, the referral document, that is Article 7 of the draft EPC, that I have annexed at page 112.
No, but are you sure that this page 63?
But they have admit.
Huh?
They have admit in the information.
No, page 63 is not part of that.
Yes, my lord, they have admit in their impugned order.
All right, we will hear you tomorrow.
No, my lord, what I beg to submit, my lord, there is a coercion of the
63 does not appear to be part of that because
my lord, they have
63
admitted.
is only 2.1, 2.21, 2.21, and then the entire page is blank.
My lord.
And then it is 2.21 performance security, 64.
No, my lord, they admit that is there. A lordship at page 140. It is their admission in the speaking order pursuant to the Honorable Court's order.
We will see tomorrow.
Page 1.
Mr. Kashyap, we'll hear you tomorrow.
Could it be on phrase admission?
Take a minute. I'll press that button. Why it has been listed for orders?
Well, because of the interim, because of the application I filed, about the communications which I received intermittent.
Press that button.
My lord, item number 48, my lord. Next item. Matter relates to installation of fire safety instrument in the SB Medical College. This matter, my lord, appears today's list as per order dated 24 June 2024. Order number 24, my lord. Relevant para is para 3, my lord. Only 2 minutes I will take.
Not today, because your representatives are coming to meet me at 4:30 because they are aggrieved by my decision.
Sorry.
But in this case, my lord, is so much pressurizing. We have already started 38 departments.
My lord,
and it is work going on.
He's doing a very good job.
That is for him only. For him only. Now
No, it is not for him. It is for the society. For the public.
Yes. Because
they are only required to file affidavit, my lord.
I have filed affidavit.
The copy has not been served.
I am serving.
Without serving the copy, they are filing the.
Please allow us to rise.
Sorry, my lord.
May keep it 2 weeks. I'm giving.
Will be listed tomorrow.
Leftover matter 54.
Yes.
Contempt matter I'm appearing today for the first time. It can come and actually there's a connected review also. So which was being heard by Justice Tomorrow
we'll see.